Good afternoon. Good afternoon. Today is, what is today? February 28th. Thank you. Oh, it is. February 28th. Welcome to the bill hearings for the Ways and Means Committee. First, I'd like to start off by welcoming all my SOARs here who are in pink and green. And I did not see you this morning, but I would like to say hello to my Madam Basilis of my chapter, SOAR Barbara. So welcome. Next, committee, we need to welcome our new member, SOAR Henson, to the committee. Today is her first day. Welcome. And with that, I will call our first bill, House Bill 963, which is my bill, and I'm just going to sit right here. Tax sales data collection, county funding. So committee, as many of you know, because a lot of you who have been on this committee have worked on these issues for multiple years, you have worked on issues to help people in tax sales so they do not lose their homes. An important part of this effort has been gathering data on tax sales across our state. We need to know how many properties are being sold, how many are owner occupied, and how many are foreclosed, so that we know how much resources are needed to help our constituents and what strategies are likely to be the most effective. The State Tax Sale Ombudsman is required by law to conduct an annual survey of counties about tax sales and publish the results in an annual report. The report is a great resource to this committee on working on those issues, and I appreciate the efforts of the Ombudsman and the counties in preparing the report and collecting the information. However, last year it came to my attention that the most recent tax sale report didn't include data about owner-occupied properties and limited data about foreclosures. I expressed my concerns about this to the Ombudsman, and I'm happy to report that he submitted a revised report that included most of the missing data. And I would like to thank Stan, the man here, for helping collect all of that information for the committee. I believe it is important to make sure that we continue to get all the data we need in the future to fill in the gaps in the data that we are getting now, so that this committee can continue to do the work on property tax sales that it is so passionate about. So House Bill 963 says that the State Department of Assessment and Taxation may not disperse funding to counties that have not provided all the tax sale data that current law already requires them to provide. It makes it easier for counties to comply by codifying the Ombudsman practice of allowing counties to provide data for the second preceding year instead of the immediately preceding year. And this gives counties more time to gather the data. Welcome, gentlemen. We started at 1. I look forward to continuing the work of the counties, the tax sale ombudsman, and all of the stakeholders to reform the tax sale process and to help homeowners. And that is it. Any questions about House Bill 963? Okay, thank you. Seeing none, that concludes the testimony on House Bill 963. House Bill 979, Delegate Terrassa. Is she here? Oh, welcome. It's her first time, and she's my district mate. Let's give her a round of applause. Whenever you're ready, Delegate Terrassa. And you have one person signed up virtually who's going to testify.
Did that work? Okay, we're not allowed to touch the mic at my committee. Okay, good. All right, good afternoon, Chair Atterbury, Vice Chair Wilkins, and members of the Ways and Means Committee. Thank you for this opportunity to present HB 979, which brings transparency to campaign financing on a local level by requiring all municipalities to require candidates running for municipal office in the state to report who contributed to their campaign and how much. This bill is related to HB 93, which was before this committee last year. While working on that legislation, which was originally intended to cover only large common ownership communities such as the Columbia Association, I was surprised, kind of shocked, to discover that there was no state campaign finance requirement for candidates for municipal elections. That bill did not move forward, and based on feedback I received last year, the common ownership communities and municipalities were separated into 2 separate bills, and that's the bill that's before you today, the one that's municipalities. Information as to where campaign money comes from and how it is spent by the candidates aids voters in evaluating those who seek office. Knowing the source of a candidate's financial support alerts voters to the interest to which candidate is most likely to be responsive and facilitates predictions of future performance. And as I said, there is no Maryland law requiring reporting campaign financing in municipalities. Some municipalities have their own requirements, and under Maryland law, if they do, candidates have to forward copies of whatever they file with the municipality with the State Board of Elections to be posted on the website, essentially so it's all in one place. However, only 35 out of 157 municipalities in Maryland require candidates to file campaign finance reports in municipal elections, and I've listed those in my written testimony. This bill would provide the same transparency for voters in the other 122 municipalities. Specifically, House Bill 979 requires municipalities to require candidates for municipal office, like mayor or city council, to file reports of donations and disbursements. It also requires those reports to be sent to the state board by the municipality within 5 days. The state board must make those reports available publicly, and as I mentioned, any municipality that already has these requirements has to do the same. House Bill 979 makes sure that voters in all municipalities have the information they need to make informed choices by making candidates in municipalities report who is financially contributing to them and what they spend their money on, just like we do as elected officials in the General Assembly. It's about transparency. And one more thing, I just wanted to address what you will be hearing from MML today. And one of the things they said was that there are, they pointed out that there are ethics reporting for elected officials in municipalities. But what I would point out is two things. One, we have to do both, right? We have to do both campaign finance reporting, and we have to do ethics reporting. But also, that's only after the election. It's only for elected officials to file. And so I don't think that would satisfy the same need as campaign finance reporting. So I urge a favorable report. Thank you.
Thank you. Just so you know, MML is not, they're not testifying orally.
Okay, well then you won't hear it, but you can read it.
We have Jeannie Massey. Let's see if she's in the waiting room. Yep. Hi, whenever you're ready, Miss Massey.
Hi, thank you for having me. Thank you, Chair Atterbury, Vice Chair Wilkins, and esteemed committee. My name is Jeannie Massey, and I live in Washington County in District 2A. Actually, I live in 2A, but 2B is the municipality of Hagerstown. And in a rural community like Washington County, the main city is really the heart of a lot of economic activity and culture as well. So Hagerstown, while I don't get to vote on our municipal candidates, I do feel like it's important for my neighbors and myself to know where they're getting their money from, in particular because politics these days is very national in scope. So knowing whether the donations for a particular candidate are coming from the local community or from further afield can make a big difference in helping us know who has our best interests in heart versus who has bigger ambitions that aren't necessarily focused on our challenges. The other concern I have about municipal elections is that Hagerstown is really very much at the crossroads of our economy. And in the last few years, we've seen the growth of warehouses in our county and city grow to a lovely total of 15. And I'm not talking about the little warehouses you see all over the country. These are the ginormous 150,000 square feet to 1 million square feet warehouses. And we have 15 of them now that are lovely and the hub of economic activity, lots of jobs. But it would be best for us to know when our politicians at the local level are able to, where they're getting their donations from so that we can make informed decisions, just as we'd like to make informed decisions about state and federal elections. Thank you. I urge a favorable report on Delegate Terrace's bill, and thank you for having me today.
Thank you very much. Any questions from the committee? Madam Vice Chair?
Thank you so much, Madam Chair, and thank you, Delegate, for bringing this bill. I was just looking over the bill, and I recall the legislation from last session as well and the work that we did on that. I just wanted to better understand. Can you say again the differences between last year's bill and this year's bill?
Okay, so yeah, thank you for that question. So last year, but included both common ownership communities, and it also included municipal elections. So they were combined in one bill. This year, I separated those out. But the other difference is that there was an option for them to go, for cities to report on the, for them to report. Okay, so there's an option for that. Last year, there was an option for them to use the state reporting system, which is much more complex. That system is, we are all very familiar with it. You have to get a treasurer, you have to get, set up a committee, all that other stuff. This year, there's not an option to do that. Instead, the cities have to require that. But for the most part, it's much better for them in that, so like if you have a small city, they can just do a very simplified form. It's whatever they decide to require. It could just be a piece of paper where you write, hey, I got, $10 from mom to help me in this election, or, $50 from such and such business, and then what they spent it on. And larger cities can make things more complex, but that's the difference.
Any further questions from the committee? Okay, seeing none. Thank you, Delegate Tarasa.
Thank you.
That concludes the testimony on House Bill 979. Delegate Fair, House Bill 1095. And I have Jonathan Glazer, and Kevin Canale is favorable with amendments. Oh, and Director Michael Higgs.
Last time I came up here, everybody was cheering because I was the last bill of the day. If we could all cheer. Yeah. Good afternoon, Chair Atterbury, Vice Chair Wilkins, and esteemed members of the greatest committee, the Ways and Means Committee in the Maryland House of Delegates. My name is Chris Fair. I'm a delegate from District 3, here presenting House Bill 1095. HB 1095 would grant more flexibility to the State Department of Assessments and Taxation to better address the demands of property assessors in Maryland. This would strengthen coordination between counties and the state, ensuring that residents have clear lines of communication when they have questions from their State Department of Assessments and Taxation. In today's rapidly changing world, it's essential that we have laws and regulations that can adapt to the real-world demands of different industries. By easing the strict requirements for SDAT, HB 1095 would help ensure that the property assessors have the tools they need to do their jobs effectively and efficiently. By improving coordination between the counties and the state, this bill would help streamline the property assessment and taxation process, ultimately benefiting both property owners and the state of Maryland. In closing, HB 1095 would be a positive step towards ensuring Maryland's property assessment and taxation system is uniform, efficient, effective, and responsive to the needs of residents and the businesses of the state. There has been an amendment that's been brought forward by MACO. It is a friendly amendment, though we are working on some language changes to it to make sure that it is still, again, efficient and effective, that SDAT can effectively do their jobs. For these reasons, I urge you to support HB 1095, and I respectfully request a favorable report.
Thank you. Mr. Canale, do you want to come up?
Thank you, Chair Atterbury and Vice Chair Wilkins, and thank you, Delegate Fair, for your bill. My name is Michael Higgs. I'm the Director of the State Department of Assessments and Taxation. House Bill 1095 would give SDAT more flexibility to better allocate supervisors to its county offices and better utilize its existing resources. For these reasons, SDAT urges a favorable vote on House Bill 1095. Thank you.
Good afternoon, Madam Chairman, members of the committee. Kevin Canale here on behalf of the Maryland Association of Counties in support of the bill with an amendment, as the delegate mentioned. So we're just looking, we appreciate the bill, we appreciate the flexibility that SDAT is seeking here to hire more assessors. We know that's a problem. And certainly there may be instances where we may not need a supervisor in each county. Our amendment would just make it clear that any proposal to consolidate supervisors would be subject to the approval of the governing bodies in question. So each county would need to sign off on that proposal. And that's important because we know that it's a sensitive subject. We have large counties, small counties, so we just want to make sure that we have the guardrails on the definition. And with that, we'd support the bill, and we're happy to answer any questions.
Thank you. Any questions from the committee? Delegate Buckle?
Thank you, Madam Chair. So, Delegate Fair, with respect to the amendment offered by MACO, that's kind of what I was thinking too. For some of us that are from smaller counties that have some geographical distances from county seat to the next, we'd like to have some ability to have input on these kind of decisions, at least at the local level, because if you take away the SDAT assessments office from that locality and move it an hour away, perhaps, if you were to move from Cumberland to Hagerstown, that's about an hour. If you were to move from Cumberland to Oakland, that's about an hour. And if you were to move that away, you lose a little bit of the local knowledge also from the assessors themselves, and then you also obviously lose the jobs, quite frankly, of those people who are located usually in sort of downtown cores and, you know, go out to lunch and do things like that in our Main Street areas. So you're okay with the counties having some input or control where they may be able to say, hey, this works for us or this doesn't work for us down the line?
Yeah, and so the exact amendment, I believe, speaks to the appointment of the person or the individual and that they are okay with it, and that's perfectly logical. That we are working on some language just around a time commitment. We find I think SDAT can speak more closely to this, but there is challenges with getting responses from some county executives at times. Their offices are obviously have a lot of things they're focused on, and SDAT has to get to work eventually to be able to do the work that they're doing.
That sounds reasonable. Thank you.
Is that fair? Okay, thank you.
Any further questions? Okay, thank you. That concludes the testimony on House Bill 1095. Delegate Hartman, no, I'm sorry, Delegate Fair, don't move. House Bill 896.
All right. I feel like all my friends left me.
And, well, Kevin Canale should still be up there,
Oh, yeah.
and then that's it for now. You got two folks, Alexander Bushel and Brian Young. You don't want to sit up there with him right now.
We're doing.
You guys are unfavorable. This is the favorable panel.
Unless I welcome.
Unless you
the
support the bill,
some support.
you can stay there.
I welcome the support.
All right, whenever you're ready, Doug.
All right. I'm going to make this short. Good afternoon, Chair Atterbury, Vice Chair Wilkins, and distinguished members of the greatest committee ever created, Ways and Means. For the record, I am Delegate Chris Fair from District 3, presenting HB 896, Commercial Property Tax Appeal Fees. During the public hearing in Ways and Means on January 19th, SDAT staff answered questions regarding the appeals process, bringing some interesting insights. And then I just lost my spot. I'm building anticipation for what those insights were. All right. During the hearing, they said, quote, "We might want to consider appeal fees for commercial accounts when every commercial account basically appeals their account and then doesn't show up 70 to 80% of the time. It's a big problem on our commercial side, not on our residential side." Another member of SDAT said, quote, "The biggest issue is that these appeals are complex, they take more time, and these commercial properties file an appeal every year. It's not just when they get a reassessment notice, they file out of cycle. It's not an issue of is it a correct value, it's an issue that they just want a new value because it's a no-lose situation and takes a tremendous amount of our time and resources," end quote. Our office has double-checked some records and found that upwards of half of all appeals heard each year are from the commercial property assessments. My goal with this legislation is simple: to help bring into account people who potentially could be misusing the property assessment appeals process to overwhelm SDAT, to force lower property assessments, costing taxpayers across all of Maryland more and more money. After some feedback, our office has prepared the following amendment to the bill. Especially after reading opposition testimony in your floor system, I'm sure you can appreciate the amendment. Instead of reading commercial or industrial property with an assessed value greater than $1 million, we are going to change that language to read income producing real property that has a value in excess of $5 million as listed on the assessment roll that is designated under subsection 8105B2 of this article. The edit to this bill will alleviate many of the stakeholders' concerns who are here today. We hope to encourage businesses and every individual to take advantage of the appeals process as is their constitutional right in the state of Maryland. I will note that in numerous other states throughout our region have appeals fees that are already applied consistently, and that our office has reached out and requested any other friendly or ideas or amendments to this bill as we go through the process. I look forward to working with the committee on this bill, and I encourage a favorable report.
Good afternoon, Madam Chairman, members of the committee. Kevin Canale here on behalf of the Maryland Association of Counties in support of the bill. The delegate did a great job explaining the issue, and you have my written testimony. I'll just add that it is a problem, especially for out-of-cycle appeals. These are automatic appeals, so these are in many cases baseless. There's not really a justification, but because they're able to appeal without providing any fee to accompany the appeal, you might as well just do it, right? And that does eat up resources from SDAT. It takes a lot of time. As you heard, these appeals are often very complex, and at the end of the day, it can result in shifting more of the tax burden to homeowners and away from commercial or industrial properties. So with that, we appreciate the amendment and we support the bill, and I'm happy to answer any questions.
Any questions from the committee? Delegate Barnes?
Thank you very much. And Delegate Fair, as I'm looking at this, how many commercial and industrial property fees are we talking about per year?
So I have some baseline data here from 2022 of just some individual county level data. For example, in Montgomery County in 2022, the total number of cases for appeals at the secondary level, which is the Property Tax Assessment Appeals Board, was 1,419 cases, of which 787 of them were commercial.
All right, you said at the secondary level, how many levels are there?
There's 3, and so the first level is a supervisory level. This bill does not impact the supervisory level. It says that that level is free for all people to apply, and then the secondary level and third level is when a filing fee would be assessed for applying.
So if we eliminate the fee, what is that as far as the revenue to the state?
Adding the fee, according to the fiscal note, would add an additional 160,000. Let me get the exact number for you here. About $160,000 annually, adding the fees in.
And then my last question, Madam Chair, looking at these commercial and industrial properties, and you said this is pretty much around the state of Maryland, where the bulk of these are coming from?
That is a great question. I don't have an answer for that, but my office can reach out to you with a response of individual county breakdowns. I have examples from Anne Arundel and Montgomery County here.
Yeah, I'm always concerned or interested in the diversity of what's going on around the state of Maryland, how this is impacting communities throughout the state of Maryland. And do we know the size of these businesses? Is there a size standard in which these commercial properties are, the fees are included?
Yeah, and that's why we first set a benchmark of $1 million to try to not negatively impact in any way small businesses or smaller businesses. We've now upped that number with the amendment to $5 million, and so with the exact same intention, which is we're not trying to harm small businesses here. We're trying to simply make sure that if people are bringing forth appeals processes, they're in good faith and not, as Kevin pointed out, just simply bringing them forward because they can and they're free. And what's the harm for them to do it?
Thank you, Madam Chair.
Thank you so much.
Delegate Hartman.
Thank you, Madam Chair, and thank you to the panel. My question, the 160,000 was based on the fiscal note of $1 million, which would represent, according to my math, over 5,000 property owners. By putting in the amendment with over 5 million, do you know how many properties that would affect?
I do not.
Potentially affect?
I do not.
So if somebody pays the $50, and I know it's minimal, but I kind of don't like when we discriminate one business or property owner from another. So if I pay the $50 and I'm successful and there was truly a flaw in the assessment, is that $50 refunded?
No, not according to the bill.
Okay. And then, and when SDAT was here, I remember the conversation. I thought their concern was a company, and I don't want to call out a name hypothetically, it's XYZ gas station. They own 100 of them in the state, and they just file a blanket for appeal for every property. I thought that was the concern as opposed to, you know, an individual property owner that may have one property. So if my thought process is correct on that, how does this
change that because or help that when we're penalizing a single property owner for the right to file an appeal because of somebody that comes in with 100 appeals blanketing every property that they own under this certain entity.
It is true that the occasional single property owner that owns a property assessed over $5 million would have to pay a $50 filing fee in that scenario. There is numerous businesses that were referenced in that hearing that currently utilize this free appeals process to clog up the system and lead to exactly what they're talking about, which is, to be clear, hundreds of millions of dollars of changed property assessment value.
But if I was, my business model may be different, and I have residential rental properties, and I have 1,000 of them, and I file that blanket appeal for 1,000, we're really not fixing the problem that SDAT brought to us, because all we're doing is targeting a property value of a certain amount as opposed to trying to correct the problem.
I would respectfully disagree with the assessment only because I would look at it from the perspective of you have a specific group of people, a specific scenario that is basically using a loophole through the process to guarantee that they're paying, that less and less money is being assessed to these individual properties. And you have a clear line that's being drawn, at least from the actual remarks of SDAT themselves, that there is a clear line of different groups and individuals who are abusing this process versus using the process as it was originally intended, which is to create a safe place for individuals like yourself to appeal a property assessment.
Okay, thank you for your responses.
Thank you, sir.
Any other questions from the committee? Quick question. So the amendment, you said the property value the property has to be income producing and it has to be in excess over $5 million.
That is correct.
So as the delegate from Ocean City just suggested, if you have 1,000 properties, you're talking about 1,000 properties that are valued at over $5 million.
Yeah.
Right. So I would suggest, and you can give your opinion, that a fee of $50 or $100 is not necessarily going to hurt that.
Yeah, and thank you. And I would agree with that statement, that it's important that we look at the reality on the ground as far as, what the amount of this fee is versus what the impact would be.
So I'm going to ask you, and this is more of a rhetorical question, so I'll try to throw "isn't that so" on there. Do you think, well, it's an actual question, do you think that the fee, because in my opinion it is low, for the qualifications of the property qualifications, the fee is low, do you believe that that fee is actually going to change the behavior that you're looking to change?
I think that it certainly, I don't know if it's, I don't believe that it's necessarily going to completely change the behavior. I think that it at least calls into account the issue and brings resources and recognizes the reality on the ground, which is that these businesses should be accountable for the appeals process. If they want to go through that process, that there is an expectation that they pay into the system that they are using.
Do you have any comment on that, Mr. Canale?
I think the fee is low, and I think we'd be open to talking about maybe relooking at it, especially with the amendment. But this certainly is a problem, and especially with the out-of-cycle appeals, it is absolutely an abuse of the system in many cases. So happy to work with the good delegate here and with the committee to figure out, the question that you're asking, whether or not it would change behavior, but at least I think it would force some skin in the game, if you will, before somebody just automatically appeals.
And I will mention that regionally, New Jersey, New York, and Pennsylvania all have similar fees in place. And those fees range anywhere from $25 to apply for a fee to $500 to apply for an appeal. So there is definitely some things on the books that could be looked at as far as increasing those fees.
Okay, thank you. Any other questions from the committee? Negative Ghost Rider. No, that concludes the testimony on House Bill 896.
I think the unfavorable still.
Yes. I'd like to call up, you can ask this panel, Delegate Hartman, Alexander Bushel, Brian Young, for 2 minutes each, please.
Hi, I'm Brian Young, testifying in opposition to House Bill 896. I'm a real estate tax attorney representing Maryland property owners for over 30 years. I'm past chair of the tax section of the Maryland State Bar. I've written the Maryland chapter of the Property Tax Handbook, published by the American Bar Association for 27 editions. I'm also the sole Maryland member of the National Association of Property Tax Attorneys. Maryland's assessment system, from SDAT to the appeal boards to the Maryland Tax Court, has historically tried to not discourage taxpayers from appealing their assessments. This bill will do just that. It will discourage and hinder the legal right to appeal your assessment. Further, charging the fee only on now a $5 million income-producing property arbitrarily discriminates against a certain class of taxpayer and does not impose the same burden on all taxpayers. Further, SDAT is understaffed, is underfunded, and as a result, many good appeals are affirmed or not properly adjusted. Thus, an appeal to the appeal board is required. This bill tries to take away or discourage or hinder that right. The Maryland Tax Court has historically been against charging a filing fee. To that end, they did not initiate this bill. Another problem with the bill is, I'm going to stop what I was going to go over. I disagree with what Mr. Delegate Fair said. There are some abuses. I review every appeal that I file, and I don't necessarily file that appeal. I tell the client, this is not a good appeal. I really hope you all ask us some questions because I have a lot more to share with you.
I'm sure you'll get some questions, sir. Thank you. Go ahead.
Hi, thank you, Chair, and thank you, Committee. My name's Alex Buchel. I'm an attorney who's been practicing in this area of the law for about 13 years now. I am opposed for a number of reasons, but principally, the fees in this bill are intended to discourage assessment appeals from certain taxpayers. Now, filing fees for courts or administrative agencies are not for the purpose of deterring appeals or access to those courts. They're for the purpose of recouping basic administrative costs evenly across petitioners to those boards, except for the indigent when they're typically waived. And the fees aren't even necessary here. The tax court did not request this bill. It did not even know about it until it was filed, and it has never sought fees for any type of tax appeal in the 50-plus years of its existence. There's no cost difference to the courts of the PTABs between processing a residential and a commercial appeal. The distinction is totally arbitrary. Now, the tax court does not charge fees for any other type of appeal either: income tax appeals, sales tax appeals, estate tax appeals. And moreover, Article 15 of the state constitution requires uniform rules for assessments and taxation of real property across classes. SDAT, the problem here is, Burton, this came up because of SDAT's concerns. SDAT is underfunded, as you know. It cannot offer competitive salaries to its staff and retain assessors. We've seen so many talented young people start a career with this department and go to Virginia, DC, where they offer significantly better compensation, and some older people too. Appeals thus often get short shrift at the first level of appeal because there's no staff, especially in the Big Five, where you've got offices now that don't even have a single full-time assessor in the Big Five due to leave or people leaving. And thus they get affirmed, and we have to appeal to PTAB to get the thing resolved. Taxpayers should not be forced to pay fees because SDAT is not properly funded to perform its statutory duties, which include assessing and handling of these appeals. So I'd urge a negative report at this time on this bill.
Thank you. Question, Delegate Hartman.
Thank you, Madam Chair. To the gentleman that spoke first, I agree with the way our minds are thinking alike, and you said much better than I could. So were there any more thoughts that you had on the subject that you would like to share with us?
Oh. How much time are you going to give me?
I don't think questions have a limit.
There are some abuses, and it's not trying to make us look good, but it's not from the attorneys that represent the taxpayers. There are firms out there that are non-attorneys that can appeal at first level and at the appeal board. They cannot represent a taxpayer at the tax court. Those are where the abuses are coming from, because they have no ethical regulation at all. Whereas I have to answer to the Court of Appeals, now the Maryland Supreme Court. If the law was actually, there's a law in place that would fix this, in the Business and Occupations article. I can't give you the source right now, but it says representing anyone before a state agency is the practice of law. When these non-attorneys are filing these appeals, they're unauthorized practice of law. And no one will enforce this. I've been doing this for 30 years, and I've tried. I've gone to various groups and agencies, and everybody says, well, we don't want to discourage people from appealing. Well, we're not discouraging people from appealing. We want people that actually have an ethical obligation to do the right thing when they file these appeals. And with these other groups, the non-attorney groups, that is where your problems are coming from.
Thank you. Delegate Barnes.
Thank you, Madam Chair. And I'm just going over the bill. So the bill says that it requires a certain filing fee when filing an appeal of a property tax assessment classification of a commercial or industrial property with an assessed value greater than $1 million. Then the good delegate said that he has an amendment to say that should be up to $5 million. Listening to the words that just came out of your mouth, you said that there are some bad actors.
There are.
You've been doing this for 30 years.
Over 30.
Over 30 years. So what the bill is intended to do, you don't think this is a remedy to fix that problem?
I don't. I think it's the tail wagging the dog. I think the vast majority, there are a number of firms that specialize in what I do, and they're Maryland-based. To answer your question, I don't think it's going to fix it. All these other firms are going to do, the non-attorney firms, they're just going to push that fee down to the client and tell them, hey, you've got a good appeal, whether they have a good appeal or not, and say, give me $50. That's who's getting hurt here, is the taxpayer, because they're going to be the one paying the bill, and it's not the non-attorney representatives that are the bad actors.
So I'm also listening to you. So listening to what the chairwoman alluded to earlier, looking at those bad actors and your 30-plus years of experience, would you say raising the fee would be somewhat of a deterrent for those bad actors?
Well, again, you're punishing the good actors at the same time. And again, you're setting up two classes, under $5 million and above $5 million. And to me, that's very discriminatory. Everyone should have the same appeal rights. The system isn't set up to treat one side.
So if we level the playing field to make it even for everybody and raise the fee, is that a good way to go?
No, because then you're going to discourage taxpayers from appealing their assessment. Because they're saying, I don't want to pay $100 or whatever the fee may be raised to. My suggestion is enforcing the law that's on the books in the Business and Occupations article. That fixes the problem, 100%. Pennsylvania's done that. Florida's done that. They have the same law, and they enforce it. We do not. That's the only way to fix it, fairly.
Thank you, Madam Chair.
Delegate Buckle.
Madam Chair, so I had two kind of legalistic questions because I practice law well. And looking at the documentation, one thing that one of you said struck me. I've done a few things to the tax court over my career, not very often. Is it correct there is no other fee to appeal for any other taxpayer to the tax court? So if you're a fee, and they have a fairly wide jurisdiction about a variety of tax disputes, and if you're within their jurisdiction and you want to appeal to the tax court, they don't charge a fee for anyone else.
That's correct.
And they've adamantly, I've been with 3 clerks of the court over my tenure. And I know the last one retired in December, and I spoke to him at a wake for the other clerk over the weekend. And he gave me permission to say he's completely against this bill. Okay. And he's watching me testify right now.
Well, that to me would create a legal concern to suggest that we only impose a fee for one type of appeal. And it leads into my second question. In some of the written testimony, I'm not sure it's from you gentlemen or not, it discusses Article 15 of Maryland's Declaration of Rights, which says the General Assembly shall, and here are the key words, by uniform rules, provide for the separate assessment classification and subclassification of land improvements on land and personal property. Is there a risk that by passing this and saying we've created a fee structure for the appeal for only this one particular subclass of commercial property valued above X amount, that the entire legislative scheme would sort of run aground of Article 15?
I think it does. I mean, I think it's clear in Article 15 that uniformity is required, and you can't set up, you know, a residential, just to use an example, a residential, there's no separate categorization differentiating commercial from residential.
So if it's $1 million, I mean, there are a lot of homes, particularly in the I-95 corridor here along the waterfront in Annapolis, that are valued at more than $1 million. Might be more than a commercial property where I live. It's sort of maybe a dilapidated warehouse. So we would impose the fee to appeal for that commercial property owner, but we wouldn't impose a fee to appeal for someone who might be exponentially wealthier, and their wealth happens to be tied up in this $20 million home.
Oh, sure. Well, I can tell you, I mean, now the bill says 5 million, but it says income producing, so they're changing it. But I understand what you're saying, but by not doing it on the residential, especially homes in Annapolis that are on the water, we're talking 5, 10, $20 million properties. Those people can afford to pay just like the commercial property owner can.
Okay.
But my point is, Article 15 says uniformity, and this sets up, to me, a discriminatory practice of differentiating arbitrarily between $5 million and, say, now $1 million.
Well, I really appreciate the sponsor's intent to try to crack down on people abusing the system by just filing a bunch of baloney appeals and sort of overwhelming the system and trying to get a result. I'm just concerned. I don't want to do anything that might run afoul and might ultimately not wind up working. So I appreciate your insight on that issue. Thank you.
Thank you.
Delegate Miller.
Thank you, Madam Chair. So I'm reading, one of the things that concerned me was, as I learned a lot last week about the assessments with farms and the impact and things like that, and especially about the lack of staffing at SDAT as far as, and the impact that that's had. And one of the things that they said is they no longer go out to properties to actually assess them. And so to me, and that's what exactly it says in our analysis that we have of current law, is that real property is valued and assessed once every 3 years. And that now, after 2018, they repealed the requirement that the department value all real property based on the exterior physical inspection, and they can just look at. So with that, it makes me seem that they might be a little bit more fraught with errors. Sure. As far as, is that what you guys have seen in the last 5 or 6 years?
Yeah,
or?
I mean, some of these errors are just simply because they don't have staff. Like, I had an incident with an assessment office recently where we had 32 properties get affirmed without a hearing. It was a total accident. I'm not there. This office is filled with great people. There's just not enough of them. And we had to appeal these properties to the PTAB. So, you know, in that case, that would be $1,600 worth of filing fees to the PTAB to just get this matter cleaned up. And a lot of things, you know, not to get into too much inside baseball, these cases, to Delegate Fair's point, are very complicated. Mm-hmm. And when the staffing is low and the volume's high, some of them, and also the other thing is they're new. The retention of the employees is not what it used to be, where when I started, I was learning from the assessors who'd been there for 30 years. But the cases then, they don't have the confidence in their skill set yet because they're new and it's complicated, and they tend not to do much, if anything, at the first level and sort of kick the can down the road to the PTAB where there'll be more time to deal with it, and maybe they'll get some more support and be more confident in what their final recommendation is.
And also to address what you're saying, the staffing issues, I want to give you a point of context. We were here testifying against another bill 6 years ago, and so about 15 years ago, I had these numbers. The assessment office downtown was kind of celebrating that they had reached 1,000 employees. And I knew what it was in 2017, but guess how many employees they had in 2017? 450. That's why they can't visit. That's why appeals get affirmed that shouldn't get affirmed and don't get proper consideration. It's not that these aren't intelligent, well-meaning people. They just don't have the time and the resources. So this bill isn't going to fix what it's trying to fix. You know, The fix is really, raising the salaries for the assessment office with the funding so that I can tell you, the Anne Arundel Assessment Office, they lost the entire assessment office within 1 year, last year. The entire commercial assessors either went to HUD, went to Northern Virginia, or to Fairfax County because they were getting double the pay. And these were good people. They were young, but they just couldn't pass up the opportunity. So that's really what's causing, to me, this bill, is that. And there are the bad actors that are doing this.
I thought the bad actors were more, from my understanding of it, and I might be wrong, was that it was the escalation of the process where it became a problem. So like the first time, the first appeal, I would be fine if there was an error, because we all know all of the things that you're saying, I'm hearing again and again as far as staffing. So if there were a waiver, if it came back as incorrect, and that's what I was trying to figure out, because in another place it says, in any of the 3-year cycle, real property must be revalued if any of the following factors cause a change in the value of the real property, and one of them is an error in calculation or measurement of the real property caused the value to be erroneous. So how are you going to know that it's not erroneous unless you have a assessment, and then if you're getting charged $50 and then there was an error, you don't get that $50 back. So that's kind of where my thinking is going with it, where I'm a little unsure about that.
Okay, there's no question pending.
Oh, that was quite, am I right about that? Am I right about that?
There's no question. So moving on, Delegate Hornberger.
Thank you, Madam Chair. So I heard a couple of scenarios where things can happen and possible resolving of the process, but in the terms, I think what the delegate's trying to get to here is that when there is a high-valued property owned by a corporation, for example, and they do hire legal counsel, and they're doing it just to, abuse the process, how do you curtail that? Like, so in other words, what's the solution because we haven't talked about the scenario where there is a big corporate property, they're lawyered up, they don't want to pay the money, and they've got all these folks on retainer. What would be the solution for that scenario?
Well, the way I practice, if it's not a good appeal, I don't pursue it.
Right,
I
but
do
we
that
have to
every year.
assume that there's actors out there that would.
Well, actors are the non-attorneys. That's the way I'm speaking.
Well, it's difficult for me to believe that there's never been a lawyer that's
Well, there could be.
willing to represent a very
But
lucrative client.
my point in the testimony is, I have ethical obligations,
Sure.
and if I do unethical things, I get disbarred. So I have to look at these things ethically.
Mm-hmm.
These non-attorney groups do not. And I can tell you, the assessors tell me who these people are, and they complain about them all the time. I'm not going to defame them here by name, but there are about 3 or 4 groups, and they do exactly what Delegate Fair said. They just, basically what we call it, they throw the stuff against the wall and hope it sticks. Or, the other term is, they just want somebody to throw them a bone so they'll go away.
Okay, and then just because I'm not a tax attorney, I don't play one on TV. Is there ever an instance where this sort of appeal can go the other direction?
Well, sure.
Okay, so in other words, bad actors could put themselves in a situation where the assessment's going to be higher than the initial.
Give you a case in point. The biggest one that ever happened was in Calvert County and this was a tax representative, not an attorney group, that filed an out-of-cycle appeal, which can be raised.
Right.
And they were challenging on this $500 million property that the mezzanine level shouldn't be assessed and $1 million should be taken off.
Okay.
The county intervened and appealed also. Ended up at tax court. The assessment got raised by $300 million.
Ouch.
This all happened because a non-attorney started the process. And once it got to that point and raised, you can't withdraw your appeal because the county's already got their appeal.
Right.
Yeah, and just to your question, and of course now I'm forgetting exactly what I was going to say. Oh yeah, and without a cycle appeals, SDAT reserves the right to increase assessments on them. So that is a big, we tend not, I think, from my understanding, my mother was a former AG for SDAT, so I've been dragged into their offices since the Hughes administration. And they tend not to use this, but in some cases when they do, there used to be almost no out-of-cycle appeals. And I think from talking to the clerks of the tax court in the past, after the last, the Great Recession of the last 2 decades ago now. There were these people who just, again, I think a lot of them weren't lawyers, some of them may have been lawyers, just started appealing properties every year, no matter what.
Right.
We tend, and when I started was after that, and we did file a lot of out of cycles, because if you recall, things were very volatile, and year to year, things could change. And assessors would tell us, hey, I get one crack every 3 years. You can come in here every year. So I'm gonna do this year, and if, you don't get a new tenant or so-and-so, come back next year, and we'll take another look. I do think that, now I don't really file that many this year. I didn't file many out of cycles. But if that's something that's abused, on those appeals, SDAT does have the right to increase assessments on those out of cycle appeals.
That's helpful, thank you.
And
Thank you, Chair.
just one last thing. Just to give you a little context, 2020, we couldn't really do anything. We didn't know the pandemic existed because it didn't happen until March. But in 21, I filed a large number of out-of-cycle appeals because the properties, hotels, apartments were greatly impacted. And last year, I only filed 5 out-of-cycle appeals. I represent hundreds of thousands of individual taxpayers and corporations. And the only reason you file an out-of-cycle appeal, the only reason you should, is if the property is damaged, you lost a major tenant, things of that nature. It needs to be something out of the abnormal. That's what the out-of-cycle appeal was intended for.
Okay, thank you very much.
Thank you.
That concludes the testimony on House Bill 896. Calling Delegate Hartman, House Bill 931. And you have Bruce Bariano, Richard Meehan, and virtually Joe Matresic. Thank you.
Thank you, Madam Chair and members of the committee. I was going to thank the Madam Vice Chair, but she's not here, but thank you for, I know, your future support of this. So House Bill 931, for the record, Delegate Wayne Hartman. This is a bill that impacts Eastern Shore Code counties, and it has to do with altering the hotel tax rate. So we started with this process last year. The town of Ocean City and Worcester County wanted to simply increase room tax from 5% to 6%. When through the bill drafting process, we found out that we are an Eastern Shore Code county, and for us to do that, we have to have the support of our other 3 code counties, which is Caroline, Kent, and Queen Anne's County. So hence we're here this year with that knowledge, reached out to Queen Anne's County, Kent County, Caroline County. We have letters of support from all 3, as well as the letter of support from Worcester County, suggesting that they have interest in doing the same. This bill is completely enabling. It does not raise any tax. It simply allows the county commissioners of those states, of those counties, and maybe some of the municipalities within those to benefit. So think about the small towns of Rock Hall, the town of Ocean City, other places that may need help with offsetting the cost of tourism. For the town of Ocean City, it's definitely that. Public safety has gone up, the price of public works, keeping the streets clean, prices have increased on all that. So it's simply to offset those costs related to tourism. So with that, I'll turn it over to our Mayor Meehan from Ocean City.
Thank you, Delegate Hartman. Madam Chair, member of the committee, thank you for having me here today. My name's Rick Meehan. I'm the mayor of the town of Ocean City. The town of Ocean City supports House Bill 931, which is enabling legislation, as the delegate stated, which would allow the county to raise the room tax from 5% to up to 6%. And again, that has to be with the unanimous consent of the commissioners. Room tax dollars fund and support our only industry in Ocean City, and that's tourism. It allows us to not only promote Ocean City as a summer vacation destination, but also to fund the festivals and events that have helped us to expand our shoulder seasons. Over 8 million people a year visit Ocean City. Over 65% of our visitors come from outside of Maryland. and the tax revenues generated from tourism benefit not just Ocean City and Worcester County, but the state of Maryland as well. More importantly, the room tax helps to cover the increased funds associated with providing the services necessary to manage our expanding season and our growing visitor base. The delegate touched on public safety and on police officers. Our budget for public safety has increased $5.7 million since the year 2020. We're looking at hiring more police officers and more paramedics in this year's budget, again, to make sure we can provide the services that are necessary to be able to take care of all the visitors that come to Ocean City. The increase in a room tax of up to 6% would help dramatically in being able to do that. You know, our goal is to make sure that Ocean City is always clean and safe and welcoming to our visitors. This additional revenue would help to do that. Public safety is 41% of our budget. This revenue would help to offset those expenses. Thank you very much, and we ask for a favorable report on House Bill 931.
Thank you. Let's see if, is he in the waiting room? No, okay, he's not here. The county commissioner's not here.
Okay.
So any questions for Delegate Hartman or the mayor? Okay, seeing none, thank you very much.
Thank you all very much.
That concludes the testimony on House Bill 931.
Just, Madam Chair, if I could note just a word of caution, everybody, there's dog's paws that are here, so when you're coming up here, be careful so that we don't injure the dog that's here. So
Thank you.
I'll guide the delegate through.
Delegate Jones, welcome back.
Family. Miss you all.
And this is House Bill 899. I have just you.
That's okay.
Okay.
Thank you so very much.
I mean, if you want to come up and talk about elections, that's cool.
It's fun stuff. Family, it's wonderful to see you. Chair Atterbury, Vice Chair Wilkins, and fellow members of the Ways and Means Committee. For the record, I am Delegate Dana Jones. Today, HB 899 is about fixing an unworkable appointment system. Under current Maryland election law, the State Board of Elections, SBE administrator, has no term limit and no term at all. They can only be removed for incompetence, misconduct, or other good cause by a supermajority of the SBE board in writing, and the process is strikingly arduous. It is all 5 seats on the SBE board must be filled. Administrator may only be removed for incompetence, misconduct, or other good cause. 4 of the 5 SBE board members must vote affirmatively for removal. Charges stating the grounds for dismissal must be in writing. The administrator must be given notice and ample opportunity to be heard. The administrator is authorized to continue to serve until a successor is confirmed by the state senate. This arrangement means that the administrator could serve indefinitely. Even if the SBE board has voted in favor of their removal, this approach lacks the fundamental accountability needed for an important public office. No other employee of the state government enjoys this level of statutory job protection. The complete lack of accountability of the state administrator to the governor or anyone else who is elected and answerable to the people is an extreme and unprecedented arrangement that offends the separation of powers and basic principles of democratic government. There are serious questions regarding the constitutionality of SBE's current terms of removal, and that is Free Enterprise Fund versus Public Company Accounting Oversight Board, 561 U.S. 477. To correct this issue, HB 899 would authorize a supermajority of the 5-member SBE board to remove the SBE administrator. This maintains protections from a political ousting of the administrator due to the political makeup of the board, while making it easier for the administrator to be held responsible for their actions. This process set forth by the bill mirrors many other of our state's laws. No Maryland public employee should be allowed to serve indefinitely or operate in the same way, regardless of position, status, or performance. After working with council, I am introducing an amendment that sets a 4-year term beginning August 1st, 2023 for the administrator to be appointed by the board with approval by the Senate. I believe it is time we bring the State Board of Elections administrators' term of employment in line with all the other states and appointed officials here in the state of Maryland. I respectfully urge a favorable report on HB 899.
Thank you. Are there any questions for Delegate Jones? Delegate Jones, how long have we had our current administrator?
We have had our current administrator for 27, about 20 years,
Okay.
close to it.
Since 1997, does that sound about right?
Then 1997 is correct.
Okay. Any other questions? Delegate Patterson?
Thank you, thank you, Madam Chair. Thank you, Delegate Jones, for bringing this to our attention. If the administrator's been there that long, what about the other 4 members? Do they rotate? Do they have a term limit? Do you know?
I don't want to step on counsel who looks as though he wants to answer.
Please do.
Council can answer.
So yeah, the members of the State Board of Elections have 4-year terms, and they're limited to 3 terms.
Any other questions for Delegate Jones? Okay, seeing none, thank you. That concludes the testimony on House Bill 899. Delegate Jones, House Bill 1200. And you have Morgan Drayton, David Guerreras, and Gregory Brown, and Janet Millinson virtually. So
Okay.
if those folks would like to...
Skip to 1200, ma'am?
Yes.
Yes, okay.
Courtney.
It's great.
Look in the front and in the back.
Absolutely.
Okay. Great. Chair Atterbury, Vice Chair Wilkins, and fellow members of Ways and Means Committee, for the record, I am Delegate Dana Jones, bringing before you HB 1200. I come before you today to reintroduce a bill that would ensure election workers are fairly compensated for their essential work. Currently, local boards of elections are not required to pay election workers a minimum wage. In many counties, the qualifications to be a judge specifically state that they should be physically and mentally able to work at least a 15-hour workday. If judges did work a 15-hour day, which many do, they would only be making $13 an hour in Montgomery, $11.50 an hour in Anne Arundel, and just $10 an hour in Frederick. For example, in Anne Arundel County, all election judges are compensated between $175 and $250, depending on position for their services. In Montgomery County, election judges are paid about $200, and in Frederick, they are only paid $150. For these long hours and frankly, shamefully low wages, it is no wonder that many local boards of elections face difficulty trying to recruit election workers. In previous election cycles, it was widely known and reported that counties were facing significant struggles recruiting election judges. Just weeks before the 2022 gubernatorial election, Baltimore City was short more than 1,000 judges. And my home county of Anne Arundel was short 300 judges just 2 weeks before the election. Maryland is on pace to reach a 15-hour minimum wage by 2025, and Governor Moore has filed the Fair Wage Act to accelerate that plan to October 1st, 2023. Considering the significant responsibility and importance of state election judges, we must do better to incentivize and retain them. Ensuring that Marylanders are paid a minimum wage is the very least we should do for these who facilitate the very foundation of our democracy. Our state's policy are a reflection of our values. If we continue to pay our essential election workers less than we pay any other employee in our economy, What does that say about the importance for which we hold these positions who administer our most treasured democratic right? I respectfully urge a favorable report on HB 1200.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. My name is Morgan Drayton, and I'm here on behalf of Common Cause Maryland to offer testimony in support of HB 1200, which, as we just heard, would establish a statewide floor for compensation of election judges. Election judges are essential to the safe, secure, and efficient administration of our elections. And regardless of what jurisdiction they serve, volunteers are expected to work up to 15 or 16 hours days during early voting and on election day. Setting this minimum threshold for compensation would not only increase equity for judges across the state, but it would also likely incentivize more Marylanders to volunteer for this position at a time when local boards are struggling to recruit and retain enough judges to fully staff our voting centers. Our elections depend on these dedicated citizens, our friends and neighbors who work long hours to serve our communities. Ensuring that these volunteers are paid more fairly is the least that we can do in return. And for these reasons, we would request a favorable report on HB 1200. Thank you.
Good afternoon, Madam Chair and Madam Vice Chair. My name is Gregory Brown. I'm the Policy Counsel at the ACLU of Maryland. I'll be quick. I don't want to repeat everything that everyone else has said, but we just at the ACLU want to emphasize how important the recruitment and retention of election judges are. The free and fair elections that Maryland offers are essential to the principles of civic duty, and making sure that we fairly compensate our election judges is critical to making sure that election day on that day goes as smoothly and as seamlessly as possible. Election judges work 12 to 15-hour shifts at minimum and are worthy of due compensation. So for those reasons, we urge a favorable report.
Good afternoon. My name is David Garris. I'm the president of the Maryland Association of Election Officials, as well as the director of the Anne Arundel County Board of Elections. Thank you, Madam Chair, members of the committee, for your time. I want to reiterate what everyone else has been saying, that we need to compensate our election judges fairly for their work that they're doing and for the hours that they're putting in. I would also like to note that over the last 10 years, we have introduced several new policies and procedures, including same-day registration, the new poll books, the new voting system that we implemented, all of these changes, and we haven't increased the pay of the election judges, and that's a problem that we need to address. Increasing the pay will certainly help us address our recruiting and retention issues. Retention of the election judges between the elections is critical, so that we can ensure that everyone has access to free, fair, and impartial elections. So we urge a favorable report and your support for this measure. Thank you.
Thank you. And I think we have someone in the waiting room. Janet Millinson. Okay.
Good afternoon, Chair Atterbury, Vice Chair Wilkins, Delegate Jones, and members of the committee. For the record, my name is Janet Millinson, and I represent the League of Women Voters of Maryland, which favors House Bill 1200. We believe election systems should help increase voter participation, and one way voters participate is in staffing our polling places. Because most Marylanders still choose to vote in person, for the recent general election, the local boards of elections had to recruit and train tens of thousands of election workers in order to staff nearly 100 early voting centers statewide and over 1,500 polling places on election day itself. This staffing effort proved to be a challenge. The pandemic conditions of recent years led many experienced election judges, often older people, to decide not to return. And although making democracy happen can be a source of pride, let's be honest, working a 15 or 16-hour day is demanding. As you heard, some of our jurisdictions pay a stipend that's less than the state's minimum wage of $13.25 an hour. The League supports having the state set a minimum compensation for election judges to apply across all counties. House Bill 1200 proposes a floor of $250 for working election day or a day of early voting, and the stipend for attending mandatory training classes would start at $50. Counties would, of course, be able to offer higher amounts if they want to. As someone who started working as a Maryland election judge in 2004, I'd love to see other people become equally enthusiastic about participating and returning in future years. Increasing the pay can help motivate them. In summary, the League of Women Voters urges a favorable report on House Bill 1200. Thank you for your time.
Thank you. Are there any questions for Delegate Jones or a member of her panel, Delegate Charles and Delegate Hornberger?
Thank you, Madam Chair. So I looked through the bill and I'm looking at the local fiscal effect of $1.6 million annually. And I'm not sure, is that broken down across all counties or inclusive of all the counties across the state? Okay, do we know specifically, because I heard you specifically say some of the jurisdictions charge or pay a little differently. I'm looking for Prince George's County specifically to see, you know, the impact on this, and because I know we're coming up on the blueprint and we're trying to make sure we cover that effectively. And I don't know how much of a fiscal harm it may cause to the county. I want to definitely make sure we have increased pay for our workers. I've been in those polling locations on election day, and these folks are working in the heat sometimes in the dead of the summer, and they need to be taken care of appropriately. I just want to make sure we have the resources to do it effectively.
Thank you so much for the question, Delegate Charles. And you're exactly right. Aside from, there's many conditions that they're dealing with, which is also the subject of my next bill before you. But for the counties that already meet this floor based on the 2022 actuals or the 2024 updated, Prince George's is one of the 5. So that is Carroll, Harford, Talbot, Prince George's, and Wicomico already meet that.
That's very good to hear.
Yeah.
Okay, let me go. All right, thank you, Madam Chair. No, I think this is a great bill. I've served as election judge before, and it's, you know, you're not in it for the money. But my question is, you know, why not go a little bit farther in terms of making them closer to a bona fide employee? Because having, again, worked and doing this, sometimes folks only show up for an hour or two, or they leave early. There's just a sort of a potpourri of people that do this, that come to these polling sites. And I don't know if just bumping up the money a small amount is going to incentivize people enough to close that gap of how many that we need currently. So would you be opposed to extending some of the benefits or making it more enticing to come work?
Thank you so much for saying that, Delegate Hornberger. I appreciate that. And I think that it's critical that we pay our election judges more than we pay those potentially who work the drive-thru at the Taco Bell. So that's the very least for which we can do. We're also talking about a larger population of retirees and other folks who supplement. We have students too that do this. So now that this is the product of the committee, I would be willing to work with you on anything that you see fit.
Okay, great, thanks.
Thank you so much.
Any further questions from the committee? Okay, seeing none, thank you, Delegate Jones. That concludes the testimony on House Bill 1200. Delegate Jones, House Bill 951. And you have David Guerreras, Kevin Canali, Joshua Paper.
So glad.
We'll call those up, and then there are 2 that are favorable with amendment that can come up after this first panel.
Yeah, you can have this one. Chair Atterbury, Vice Chair Wilkins, and fellow members of the Ways and Means Committee, for the record, I am Delegate Dana Jones, and I am here to speak to you today with this amazing panel on HB 951. This bill would expand prohibitions on interfering with election workers, make it illegal to publish the personal information of our election workers or their families, and establish a process through which election workers can request for their public information to be hidden from public view. Recently, our country has experienced a disturbing rise in political extremism and violence. Less than 2 weeks before the 2022 elections, the Department of Homeland Security released a bulletin warning of a heightened threat of violence. Specifically, they cautioned that potential targets of domestic violence extremism include, quote, candidates running for public office, elected officials, and election workers. This warning is extremely concerning and understandably worrisome to those who work as election officials, as well as those who have considered it. According to a survey published by the Brennan Center for Justice at New York University Law School, 1 in 5 election officials are unlikely to continue serving in that role through 2024. As we discuss the problem of election worker recruitment and retention, we must take into account the safety of our neighbors and of our election officials. HB 951 is meant to address these issues and make our elections, and especially those critical to its function, safer. This bill expands the definition of interfering with an election official and increases the criminal penalty for doing so. Additionally, this legislation criminalizes the act of doxing election officials, which making it illegal to publish the personal information of an election official or immediate member of their family. Finally, HB 951 creates an avenue for election officials who have been directly threatened to request their personal information be hidden from public view. I have worked with SSTAT, who is here somewhere, and the Amendment Office to introduce an amendment to encompass election workers into the Secretary of State's Safe at Home program in order to lower costs associated with this bill's implementation. I am proud of HB 951, and I believe we must act to preemptively to protect our election officials in an unfortunately increasingly polarizing atmosphere. And I have some amazing folks here with me today to talk about their experiences, how they feel about the bill, and I am available for questions, you know, or a group hug from everybody afterwards, so whatever. Thank you so much, Chairwoman. You want to go next? Okay. Oh, it was already.
Good afternoon, sorry. Madam Chair and members of the committee. For the record, my name is David Garris. I'm the president of the Maryland Association of Election Officials, as well as the director of the Anne Arundel County Board of Elections. We are in support of HB 951. We believe this is relevant and necessary legislation, especially in this in the environment that we find ourselves in. The safety and security of our election judges, election officials, and staff is paramount. The people on the front lines with the public during the election process need to be safe and secure and know that their information and their personal safety is protected and is being carefully considered. We urge you to take this opportunity to proactively address this concern before it becomes a much more serious issue, especially in light of the coming elections. This sort of activity where folks are going to the polling places to dox people or to disrupt the election process, it scares away voters. I'm sure that during the 2022 election at Pip Moyer, folks were definitely scared away by some of the activities that were going on there. It reduces trust in the process to see that people are openly flaunting the election process at the polling places. And it will keep people from stepping up from being election judges. It will definitely cause our current election judges to quit, and it will make it very, very hard to replace them, especially with newer folks that understand the threat of doxing and how disruptive and awful it can be if you're caught into that into that web. So we urge you to please give us a favorable report and support this legislation. Thank you.
Okay. Good afternoon. My name is Robert Ray, and I have been serving as one of the chief judges at various polling places in Annapolis since 2008. Obviously, a slow learner. During the most recent election, during early voting, we had an incident at the Pitt Moyer site where an individual appeared at the door with a body-mounted camera as well as a handheld one. He was blocking the doorway as he was attempting to film the proceedings going on in the polling place. I approached him and tried to have him move out of the voters' way. He refused, so I called Annapolis City Police. As we were waiting for them to respond, several other election workers and one employee of the Anne Arundel Board of Elections came out to assist with the situation. A confrontation developed when the board employee attempted to push a camera away from his face. Both individuals fell to the ground and the cameraman hit his head against the wall. All the incident was recorded by him and subsequently appeared on his website with a false claim that 4 election workers had jumped him and beat him up. He included the board employee's name as well as mine, identified as Bob Bray. He attempted to file charges, but the state's attorney refused to proceed. His website has a fairly large following, and the story of the incident started to appear everywhere, to include the local newspaper. I personally received numerous calls asking why 4 of us had beat this guy up. I'm 79 years old, and you can see I'm not what you call muscle bound. Situations like this make it extremely difficult to get people to volunteer to fill these positions, and a lot of people who were there during this one are thinking twice about serving. Thank you.
Madam Chair, members of the committee, Kevin Canale here on behalf of the Maryland Association of Counties in strong support of the bill. You have my written testimony. I'll say me too. I'll add the pieces about doxing in this bill are particularly important. This is common sense. Nobody wants to sign up to be an election judge if you're worried that your license plate's going to end up online, pictures of your kids. You're going to get these threats. It's happening here in Maryland and across the country, and it's past due that we address this issue and make sure that we protect these folks. So we'd ask for a favorable report, and I'm happy to answer any questions.
Thank you. Committee, are there any questions for this panel? Delegate Patterson.
Thank you, Madam Chair, and thank you, Delegate Jones, for bringing this legislation to our attention, because I too was concerned in my county when we had a really challenge getting election judges. I'm thinking in visualizing or trying to visualize, I know with doxing, thanks to Delegate Eversole, he shared with me what it means. But I have a question in terms of the election judge from Anne Arundel County. How do you see this operationally working? Is it that you would have police officers to come in, or the election judges would call the police officers when there is someone who is acting inappropriately or threatening?
Well, for Election Day, the procedure would still be if somebody is threatening the safety or security of the polling place, call the police, call 911. Don't tolerate any sort of interruption or disruption in the electoral process. The bill helps us because it gives us an avenue for after the fact, like with our election judges and our staff, they put everything on the internet and they put it on their websites. So we can go back and hopefully scrub the internet and try and get that stuff removed from the public view. I mean, for instance, I personally got calls from a person in Nevada talking about this incident in Annapolis, and there's no reasonable way they should be, trying to even have an opinion about an election in Annapolis, So that's just sort of the thing that you get exposed to. You get people who are coming after this with no stake in the game. So that would help prevent that sort of interference.
Absolutely, thank you.
If I may add, Washington State and Colorado have both passed similar legislation, and several other states throughout the country are looking at this because doxing is such a problem and being used against our election workers. So just wanted to add that.
Delegate Henson.
Thank you, Madam Chair. Thank you, Delegate Jones, for bringing this very important bill, and thank you for the testimony that was provided today that really gave context to what was experienced in Annapolis. I believe the incident in Annapolis started with the gentleman filming or attempting to film inside of the election site.
Yes, ma'am.
Thank you, sir. Does this bill prevent that from happening?
This bill really talks to how we can deal with these folks. Right now, we're not supposed to be filming anyway inside of a polling location or taking photos. Bob, did you want to add anything to that?
Well, this gentleman is well-known provocateur
Yes.
here in the Capitol, and the police knew him. And the fact that he was so well-equipped with all this filming equipment and recording equipment was just unbelievable. And then he came back, not the next day, but the day after that. He came back again, and we had to have the police come and remove him that time.
I hope we can do something to address that underlying issue as well of him filming, because to the point that you have in the bill, the safety concerns of the workers, what was exposed there were people who were coming in and out to vote, and also the workers as well. So hopefully we can address that in the future. Madam Chair, may I be permitted a follow-up? Thank you very much. As it relates to the doxing portion, the sharing the personal information, would that crime be applicable to someone who also reshared that information? So if the initial user makes it available and someone then echoes that with a share or retweet or however you do that on the other platforms, would they be guilty of the crime as well?
That's something that we would need to check with council on and get back to you.
Sure, thank you. And thank you for bringing the bill, and thank you for your testimony. Thank you, Madam Chair.
Thank you. Any other questions? So Delegate Jones, is it correct that the state board has current regulations which forbids the filming inside a polling place? Is that accurate?
Yes, Chairwoman, it is correct.
Thank you. Okay, seeing no further questions, that concludes this panel. We have two other individuals, Jonathan Glazer and Director Higgs. Please come up.
Thank you so much, David. Thank you so much.
Thank you, Chair Atterbury and Vice Chair Wilkins. My name is Michael Higgs. I'm the Director of the Maryland Department of Assessments and Taxation. State Department of Assessments and Taxation supports the concept of House Bill 951. However, SDAT requests that this new program be modified to mirror the requirements of the Maryland Safe at Home program established through the State Government Article 7-301. SDAT greatly appreciates the sponsor working with the department to implement this amendment, and for these reasons, SDAT urges a favorable with amendment on HB 951. Thank you.
Thank you. Are there any questions for SDAT? Okay, seeing none, thank you. That concludes the testimony on House Bill 951. House Bill 867 is Baltimore City Bill, and we will welcome this committee's former member prior to my tenure here, Delegate Smith.
And Madam Chair, for the record, Delegate Stephanie Smith, honored to be before you in person as Chair of the Ways and Means Committee, and welcome our new Vice Chair, Wilkins, and also hello to all my distinguished former colleagues and new colleagues to the Maryland General Assembly. I will be presenting House Bill 867, which is a bill that was introduced at the request of the administration for Mayor Brandon Scott. And this particular bill is an outgrowth of we had a work group that was focused on tax sale and how it impacts our communities and residents. And so we have a couple of proposals, of which this is one that came out of that work group. So what this bill does is it gives Baltimore City the authority to create our own tax collection system, which would include working with residents that are in arrears by canceling the tax sale and providing payment plans and supports. There are many individuals who are economically fragile that can pay back when there's a payment plan or some type of interval of payment, but sometimes bulk payments can become very difficult. This uses NREM foreclosure only when the resident does not pay after extensive outreach, approximately 3 years versus 6 months in regular tax sale. No additional fees are placed on the residents and support is provided. This is not something that we want to do again and again. This is very much a last resort. The purpose of this bill is to just increase stability for owner-occupied households, particularly many of the households that are vulnerable to tax sale that are owner-occupied are seniors, and particularly senior women. And so we know that in many communities that are facing uneven economic realities and distress, we want to stabilize ownership and occupancy in those homes that do have long-term, often legacy residents in there. This bill is designed to provide additional protection and support to property owners. Robust, affordable, easy access to payment plans are central to the support being proposed for property owners. The city is already authorized to offer payment plans in many circumstances. This bill broadens to these circumstances at issue. Research has shown that when payments are affordable, revenue increases. Financial projections indicate long-term positive revenue from this change for Baltimore City policy. It also authorizes the mayor to cancel the sale if necessary. This is important because the city is currently required to hold a sale each year within its existing system. As we implement a new system, there will not be a need for the current annual tax sale particularly. Finally, the bill allows the use of NREM foreclosure process in the event property owners do not address their obligation in a minimum of 3 years. The current system requires 6-month delinquency before entering tax sale, I'm reiterating, and the additional time and payment plan options are specifically designed to support property owners in retaining their homes. And so that concludes my presentation of House Bill 867, and I do hope to receive a favorable report on this local measure. Thank you so much, Madam Chair and Madam Vice Chair. It is so exciting to be before you both.
Thank you. It's exciting to have you here. Any questions for Delegate Smith? Okay, seeing none, that concludes the testimony on House Bill 867. And now calling House Bill 921, Delegate Smith. And I'm just going to call all the folks that you have here. Claudia Wilson-Randall, Jonathan Glazer, Director Michael Higgs, Nina Themlis.
Nina won't be speaking, but we do have a deputy mayor who will be speaking on behalf of the city, if that's okay. Justin Williams, that I believe is registered.
Okay.
I think she registered him.
Okay, come on. Yeah. Okay. And then I also have Dan Ellis, Joseph Kirschner, and Councilwoman Odette Ramos. And then you have 2 people that are virtual.
Okay.
So, okay, we'll do this panel and then let the other 2 folks come
Okay.
up. Okay.
No
Whenever
problem.
you're ready.
Thank you, Madam Chair. For the record, Delegate Stephanie Smith, here to present House Bill 921. This is legislation that is also a result of the convening of the tax sale work group, which was established in the fall of 2021. And this group met over the course of a year and discussed ways that we could improve outcomes for residents who have had their properties sent to tax sale. This piece of legislation would expand the types of properties eligible to go through the NREM process that is underway in Baltimore City to ensure that the city has more opportunities to reduce the number of vacant and abandoned properties throughout the jurisdiction. We have Deputy Mayor of Economic and Community Development, Justin Williams, as well as Dan Ellis, who is the co-chair of the tax sale work group, as well as Joseph Kirschner from the Department of Housing and Community Development, here to provide more of the particulars. I'm grateful for the opportunity to present House Bill 921 and do urge you to grant a favorable report. Thank you, Madam Chair.
Thank you, Madam Chair. For the record, Justin Williams, Deputy Mayor for the City of Baltimore for Community and Economic Development. I'm here to basically co-sign what Delegate Smith mentioned and to underscore Mayor Scott's support for this legislation, and to thank Dan Ellis, who's here to testify next, who was one of the co-chairs of the tax sale reform work group, which met starting back in 2021, and want to thank them for their efforts, and thank the advocates here for their efforts and diligence to protect the vulnerable homeowners and residents who are impacted by tax sale. This particular legislation addresses the issue that Baltimore's been tackling under this mayor's leadership with vacant housing. The issue with the current system with tax liens is that when a tax lien investor acquires a tax lien certificate, they may or may not go to the foreclosure process, but the next step is they don't get the deed to actually transfer title to the property. So there's a window during which properties are in limbo. The city can't figure out who to hold responsible for repairs. It's also in instances where the property has value, the tax lien certificate holder can wait and raise the price and then eventually acquire the deed and then give it to the new owner, which increases fees and makes it harder to redevelop properties in the way that the city and the community stakeholders would like. The other concern, and this is the practical matter, is that, and it's probably the reason there's some opposition to this legislation, is that there is existing interest payments that go to the tax lien certificate holders of 18% interest, and as a practical matter, the interest can and should go to the city as a way to help subsidize the activities we're doing to protect vulnerable homeowners and to promote development community. So I'll let Dan Ellis speak to more details, and we just urge this committee to support.
Good afternoon. Thank you, Madam Chair and members of the committee. I am Dan Ellis. I am the Executive Director of Neighborhood Housing Services of Baltimore, and I did serve as co-chair of the Baltimore City Tax Sale Work Group appointed by the mayor. Our work group really looked at how do we address the problem of vacant properties in Baltimore with regard to tax sale. And we set out a goal of designing a system or implementing a system where in 6 to 9 months, the city could identify a property and move it to city control of what the outcome is. And in 2019, this body authorized, and we have since implemented in Baltimore, an NREM tax sale foreclosure process that allows for a much faster process than traditional tax sale. That authorization in 2019 allows us to do it on properties where the liens exceed the assessed value. What House Bill 921 does is it expands the use of NREM to a broader sector of properties. And so it really looks at allowing all vacant building notice houses and lots that are in Baltimore City that have tax delinquency on them to be able to move through this process of NREM. And that's important because it allows the city to control the outcome. One important question is how do you ensure due compensation at the end of the process to the prior homeowner if it's not underwater? So there are 2 recommendations that are included in the bill. The first is the city can hold an auction, at which time fair market value is determined by the winner of the auction, and the court disperses proceeds accordingly. The second mechanism is to have an appraisal done, which determines fair market value, and again, the court distributes properties or the proceeds according to priority. And so we are looking forward to being able to expand the use of this in Baltimore City with your permission. It's a critical tool to really help with the redevelopment of Baltimore, and we respectfully request a favorable report on House Bill 921. Thank you.
Thank you, Chair Atterbury and Vice Chair Wilkins. For the record, my name is Michael Higgs, and I'm the Director of the Maryland State Department of Assessments and Taxation. SDAT supports Baltimore City's strategy to use in-rem foreclosure to expedite the process of returning nuisance properties to productive use. The bill would make properties designated as nuisance by the Baltimore City Building Code also subject to in-rem foreclosure, and it would permit the city to determine the lien threshold. In-rem foreclosure is a process by which Baltimore City can foreclose on a vacant lot or vacant building if the municipal liens exceed the assessed value of the property. Baltimore City often reports that vacant and nuisance properties regularly cycle through the tax sale process each year and have negative impacts on the community. This bill provides a potential solution to this issue. For these reasons, SDAT urges a favorable vote on House Bill 921. Thank you.
Thank you. Are there any questions for this first panel? Delegate Charles?
Thank you, Madam Chair. I actually really like this bill right here. Blight and vacant homes deteriorate our communities drastically. When you see these homes, specifically, we have some in Prince George's County that are literally tearing down the values of our surrounding communities and the surrounding homes. And so I see that this is a bill specific to Baltimore City. Is there a way that we can have counties opt into this? Is that something that is available at this point, or something that we should be adding to this bill as an amendment?
I would probably defer to council. I don't see why that would be a problem, but I would have to defer to council to see what's possible.
Thank you.
We're all about big hugs. We're over here. Bringing it together.
Any other questions? Okay, seeing none, thank you. Did we have Claudia Wilson Randall here? Come on up, please. Councilwoman Ramos. And gentlemen.
I can go first. Yeah, actually, I'm on roller skates. So, good afternoon, everyone. My name is Claudia Wilson Randall. I'm the Executive Director of the Community Development Network of Maryland, and CDN has been a part of the ongoing work of reform of the tax sale process for quite some time. And I am also a member of the Mayor's Task Force on tax sales. House Bill 921 is just, I just want to emphasize what the earlier panel said. It's just a needed tool, one of many tools that the city needs in order to address vacant properties and nuisance properties. The one thing, as a member of the Community Development Network of Maryland, I want to emphasize is we can talk a lot about legal property, property holding, property rights, nuisance properties, blighted properties, but we also want to focus the work that needs to be done on people and the impact of vacancy in Baltimore on people, on the health, wealth, violence in Baltimore is directly tied to the amount of vacant property. So we need all the tools that are in the toolbox to address this issue. I don't want it just to be about property and real estate. I think that the work of community development and our partners across the state has to do with making communities better, building opportunity for people in Baltimore City and throughout the state. And I just want to make that point. I would like to ask your favorable report for House Bill 921, and I'll turn it over to my colleagues. Thank you so much.
Good afternoon. My name is Joseph Kirshner. I'm the managing attorney at the Department of Housing and Community Development for Baltimore City. We're the agency that currently employs the in-rem foreclosure law, and we're currently using it to address vacant lots and vacant buildings where the liens exceed the value. This bill would allow the city at its option to expand that pool of properties to include nuisance properties, which would give us another tool along with code enforcement to address properties that are affecting quality of life in the city. Another thing that this bill does is it increases the notice requirements to the interest holders. And so that will help to ensure that anyone with an interest in the property gets the notice that they're entitled to under the Constitution. It also makes sure we end up with better title. We end up with insurable title at the end of the process. And then finally, it provides for the distribution of excess funds to the interest holders to make sure that where their interests are affected, they're compensated, if indeed we're dealing with properties that have value as opposed to properties where the liens exceed the value. I urge a positive recommendation. Thank you.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. My name is Odette Ramos. I am councilwoman for the 14th District in Baltimore City. It is wonderful to be back in Annapolis. Familiar with these halls in my former role that Claudia now has. This is the second step in the work that we've been doing. The current in-rem law was passed in 2019, and it was a bipartisan bill here in Annapolis that all of your jurisdictions can take advantage of, to your question, sir. This particular bill is Baltimore City because we really need, I'm not opposed to making it statewide, but we started with this in Baltimore City because we are in dire need to expand the in-rem process from where when the liens exceed the value of the property, we can foreclose, to where the liens are below the value of the property, but it is still very clearly a vacant property. Let me explain. In my district, I have a wonderful, diverse, amazing district. There are 2 neighborhoods in my district that have the most vacant properties. We did a study. The 450 vacant properties in those 2 neighborhoods, 28% of them are ready for in-rem right now. An additional 35% are approaching in-rem. So this bill would address those additional 35% immediately. That's 65% of my vacant properties that we can take action on immediately. And when we say immediately, we don't mean tomorrow. We mean this process is about 6 to 8 months, so that the city can take control of the properties and with the community come up with what the solution will be for those properties. This is a game changer. This is exciting. We need your help. And I'm asking for your support of this bill so that we can accomplish those goals, not just in my district, but across the city. Thank you.
Thank you. Are there any questions from the committee? Okay, thank you very much.
Thank you very much.
We have 2 folks that are here virtually. Garrick Good.
Hi. Can you hear me?
We can hear you, but we cannot see you.
It says that camera's been
Oh,
disabled
there
by
you are.
the.
No, we can see you now whenever you're ready.
Okay, greetings, Chairman Atberry and committee members. For the record, I am Garrett Good. I'm the Executive Director of Northeast Housing Initiative in the City of Baltimore. I have submitted my testimony via writing, but also would like to add to that that we are in support as part of Northeast Housing Initiative for a favorable response of House Bill 921. One of the communities that we steward is a neighborhood called the 4x4, in which there are 600 homes. Of that 600 homes in that community, there are over 100 that are vacant and abandoned from blight. And this bill would provide the tool necessary for us to be able to bring in more homeowners. We support families at 50% AMI all the way down to 30% AMI, and we steward them even after they have taken home ownership. And we, with that, do support the bill and look for a favorable response. Thank you.
Thank you very much. Any questions for Mr. Good? Okay, thank you, Mr. Good. Next, Shanna Roth-Gormley.
Good afternoon. My name is Shana Roth-Gormley. I'm an attorney at Community Law Center. We are a legal services organization which represents nonprofits and community groups in Maryland. And I'm testifying in support of HB 921 today. Because we've seen the ways that vacant and nuisance properties impact communities and the ways that tax cycle furthers and increases the cycle of vacancy and disinvestment in Baltimore communities, and would like to see this in-rem tool that's so promising and already has so many applications, see it expanded so that more properties in Baltimore can take advantage of this. We've seen the ways that when there's no market for these vacant and nuisance properties within the existing tax sale system, those properties just cycle through tax sale year after year while the properties continue to deteriorate, to attract crime and illegal dumping, to require municipal resources, and cause harm to communities and neighboring properties. Expanding the in-rem tool by passing this bill would be a win for communities who would sooner see the vacant, deteriorating properties in their neighborhoods cleared of liens and become available for new ownership and productive use. And it would also be a win for Baltimore City and for the state in terms of revenue collection. Putting a new property owner into the property with a new use can get taxes flowing back in and get the property free of its ever accumulating lien burden. And it also gives opportunities for the property owner to get that notice, to respond, and have the opportunity to take action on the property. So I urge a favorable report on HB 921. Thank you.
Thank you. Are there any questions for Ms. Roth-Gormley? Okay, seeing none, thank you. That concludes the testimony on House Bill 921. House Bill 898, Delegate Feldmark. And you have Isadora Stern, Claudia Wilson Randall, Lorna Henry, and Kevin Canale. Good afternoon, Madam Chair and committee members. For the record, I'm Delegate Jessica Feldmark, and I'm here to present House Bill 898, the first in a series of fabulous bills I'll be sharing with you today. House Bill 898 deals with the renter's tax credit and the homeowner's property tax credit. And as you know, we as a committee have been discussing these programs quite a bit. And going back to the briefing that we had early in session, one of the things that really jumped out at me was the fact that these programs, which are based on income eligibility, the income eligibility thresholds are outdated and therefore much lower than the policy decision at the time they were set. So, for example, the homeowner's property tax credit, the income eligibility threshold is $60,000. That was set at $60,000 almost 20 years ago. $60,000 is not nearly as much as it was 20 years ago. So if we adjust that for inflation, that $60,000 policy decision in today's dollars should be an $87,000 income threshold. And so what we did was, for both programs, basically just adjusted for inflation from when those thresholds were originally set. And then we're asking SDAT to, every 3 years, reevaluate and report to the General Assembly so that we can make the policy decision about how those thresholds should be adjusted. Now, I know this is a responsible and studious committee, and you may have looked at the fiscal note. It is an ambitious fiscal note. I will acknowledge that. But I do think this is an important issue that we need to be looking at. And if we can't fully correct to adjust the cost, I hope we will at least engage in looking at making some progress in that direction. So I'm going to keep my remarks very brief. There are several folks for you to hear from, but I do ask for your favorable report, and I'm happy to answer any questions.
Good afternoon, Madam Chair Atterbury and members of the committee. My name is Lorna Henry. I'm a staff attorney at Maryland Legal Aid. We appreciate the invitation given to us by Delegate Feldmark to testify on this very important bill. As the largest nonprofit law firm in the state of Maryland, we serve each of the state's 24 jurisdictions, and we know how impactful this legislation would be to the residents in this state. This bill is vital for elderly and low-income Marylanders trying desperately to stay in their homes, especially during a time where inflation has caused food prices and gas prices and other necessities to increase significantly. The property tax credit helps our clients in many ways, and especially for homeowners, it helps them to avoid tax sales where an unpaid property tax bill of as low as $750 could cause someone to lose their home as well as all of the equity in their home. And I'm sure sometimes bills cross your desk that are unreasonable and unfair, but this is not one of them. It is a fair thing to do to increase the income limits for both renters and homeowners trying to get the property tax. We don't want an otherwise eligible renter or homeowner whose income has increased as a result of rising food or gas prices to now disqualify for a tax credit that they would normally qualify for. This bill is also forward-looking in that it requires a reassessment of the tax credit every 3 years to determine if income requirements should be further adjusted due to inflation. It is very important that people who need the tax credit the most receive it. I had a client who was 78 years old, who had her disabled son living with her, was on a fixed income, owned her home for over 15 years, and because she did not apply for the homeowner's property tax credit in 1 year, her mortgage payment increased by $500 per month. And now she was at risk of losing her home due to foreclosure. Thank you, committee.
Good afternoon, Madam Chair, Vice Chair, and members of the committee. My name is Isadora Stern. I'm a policy manager with Economic Action Maryland, formerly the Maryland Consumer Rights Coalition. We are a statewide nonprofit, and we work to expand economic justice and equity in Maryland's vulnerable communities through our direct service, our education, research, and our advocacy work. We have several direct service programs that focus on creating access to safe, affordable housing and removing barriers to economic well-being that disproportionately affect low-income individuals and communities of color. One of those programs is our SOAR program, which stands for Securing Older Adult Resources. This program works to improve the financial well-being of older adults in the state. Our SOAR program has several counselors who work with individuals to secure those tax credits along with other benefits, do outreach in the community, and spread awareness about these tax credits that are often left on the table. We know that inflation is at an all-time high, a 40-year high, and this bill looks at expanding eligibility, which will just help more older adults take money off the table and put that in their pockets. These are folks who are living on a fixed income. We have studies that show that folks need about $40K right now in order to live independently in their homes. This just gives them the money to do that, to age in place with dignity and stay in the communities where they are often community leaders and tenants in that community. So we are here in full support of the bill and are happy to answer any questions. Thank you.
Good afternoon, Madam Chair, members of the committee. Kevin Canale here on behalf of the Maryland Association of Counties in support of House Bill 898. You have my written testimony. I'll try to be brief. This is a good bill. This bill makes a lot of sense. You heard a bill earlier this session that authorized counties to grant a property tax credit if someone had suffered a hardship and therefore fell out of eligibility for the homeowner's property tax credit. The goal here would be to avoid that situation entirely. I think you could say right now a lot of people are suffering a hardship because of inflation. It makes sense to go back and look at these values in terms of should we be updating the amount of income that helps people qualify for this program? Yes, absolutely. It's been 20 years, as the good delegate noted. And I think, ultimately here, counties want to keep people out of tax sale. I think this is a way to improve the process to help more people qualify for these great benefits and thereby keep people out of the tax sale process. And we've consistently supported bills to do that. We think this will help people stay in their homes, remain in their homes. And with that, we'd ask for a favorable report. I'm happy to answer any questions.
Thank you. Ms. Wilson-Randall, did you want to come up and testify? Is she in here? Claudia Wilson-Randall?
I don't see her.
Okay, she must have left. Well, then that is it. Any questions for this panel? Okay, thank you. Seeing none, thank you very much. That concludes the testimony on House Bill 898. Delegate Feldmark, you are wrapping up our day here. House Bill 897, and I have Isadora Stern, Claudia Wilson-Randall, Jonathan Glacier, and Director Higgs, and Lorna Henry. And you have one person that's virtual after we. Do we have enough seats? Yeah. Whenever you're ready.
Thank you. Good afternoon again, Madam Chair, Madam Vice Chair, and committee members.
For the record, still Delegate Jessica Feldmark, presenting House Bill 897. This is actually the last bill I have that I will be presenting on the homeowners tax credit this session. And this is actually building on a concept we tried previously to allow for automatic renewal. And this is not quite automatic renewal, but it is easy renewal, and that is progress. So House Bill 897 would allow homeowners with certain limited fixed income. So their only sources of income would be from benefits under the Social Security Act, a pension, or an annuity. As long as those are the only sources of income, we know we're not going to see a lot of fluctuation in their income, right? And so what this bill proposes is, rather than requiring them to fully reapply every year, they could apply every 3 years, pending a certification each year that certain information has not changed. And we are working on an amendment with council to clarify that. So they would be certifying that the homeowner resided in the dwelling for at least 6 months in the preceding year, that they continue to have income only from Social Security, a pension, or an annuity, and that the homeowner's household size has not changed. So with a recertification of those simple elements, then SDAT would be able to process the renewal without requiring the full reapplication and submission of all that documentation. So again, you're recognizing a theme. We're trying to streamline. We're trying to make it easier for folks who are eligible for these benefits to access the benefits they need to stay in their home. So thank you, and I ask for your favorable report and happy to answer any questions. Good afternoon, Madam Chair. Oh, yes, thank you. Good afternoon, Madam Chair Atterbury, members of the committee. Again, my name is Lorna Henry. I'm a staff attorney at Maryland Legal Aid, and we appreciate the invitation from Delegate Feldmark to testify on this bill. This bill is so important, again, because it helps people get the tax credit who need it the most. It makes the process easier, simpler, and less time-consuming. This bill would benefit our elderly population, retirees, widows who are receiving Social Security, pension, and annuities, also low-income and disabled people receiving SSI or SSDI. These are the clients that Maryland Legal Aid serve. Every year we send out a letter with the application to remind our clients to apply for the tax credit, and we help them complete it. For some of them, the application is difficult and they never finish the process. For others who are on fixed incomes and don't have to file taxes each year, they forget to apply, and so they never receive the credit. Requiring an application every 3 years is a good thing for homeowners, and it also makes it easier for legal services organizations like Maryland Legal Aid, because we don't have to work hand in hand every year to ensure that these vulnerable communities get the credit, which helps them avoid foreclosure and tax sale. This legislation would allow us to direct our resources in more targeted ways, which would not only benefit us, but also the other clients that we serve. This is a necessary and practical bill that makes it easier and simpler for our most vulnerable populations to get the tax credit each year. Missing just 1 year could be the year that the property tax credit becomes too high for them to pay, and they fall into foreclosure or tax sale and lose their home. We want to avoid that. Maryland Legal Aid strongly supports passage of this bill and urges a favorable report. Thank you.
Good afternoon, Madam Chair, Vice Chair, and members of the committee. For the record, my name is Isadora Stern with Economic Action Maryland. My last testimony, I detailed our SOAR program, Securing Older Adult Resources. We work with older adults to secure these vital credits to help them age in place. In 2022, we screened 335 folks for these credits, and we are anticipating returning close to 500,000 dollars through these credits to these folks. Again, these are going to financially fragile older adults who both own homes and rent. So we are in full support of this bill. These are for homeowners, older adult homeowners. Every time these folks come into process with the application, they risk either not completing the application fully. Some of them have become confused between the homestead tax credit and the homeowners, so they're not always looking every year to resubmit their application. And also, memory loss is a natural part of aging, and this is something that our clients are struggling with. Extending the application for 3 years, it also frees up our resources, gives us the opportunity to work with new clients, secure more tax credits to people who need it, and do work in the community to spread awareness about this important campaign. So we urge a favorable report, and thank you for your time.
Thank you, Chair Atterbury and Vice Chair Wilkins, for allowing us to testify today. My name is Michael Higgs. I am the Director of the Department of Assessments and Taxation. I have with me Jonathan Glazer, our Legislative Director, if anyone has any technical questions about the bill. House Bill 897 would reduce the amount of paperwork that certain applicants need to submit to ESTAT for the homeowner's tax credit. For applicants who continue to have an income solely from Social Security, a pension, or an annuity, and have met certain other requirements, the department will permit the applicants to submit a mini application every second and third year. This bill is the result of several years of ongoing work led by the sponsor to streamline the homeowner's tax credit application process. Thank you very much. For these reasons, ESTAT strongly urges a favorable vote on House Bill 897. Thank you.
We will go on to Ms. Harris, who is with us virtually, and then questions. Ms. Harris?
Hi, good afternoon. I'm Allison Harris, Director of the Home Preservation Project at the Pro Bono Resource Center of Maryland. Today, I want to tell you the story of my client, Janet, to help you understand what happened to her and how the passage of HB 897 could have helped her and others in her situation. Failure to apply or reapply for the credit in a timely manner frequently lands families on the tax sale list. Janet would have been one of them, but for the fact that she came across my desk as a client at one of our estate planning clinics and mentioned that she had delinquent property taxes. She was very worried about losing her home, which was her only asset to tax sale. Janet was 68, had owned her own home for 22 years. She does not have a mortgage. Her annual income is less than $15,000, which is food stamps and Social Security. She'd had the homeowner's tax credit for years and relied on it to be able to afford her property tax bill. For some time now, she's been going to a local outreach center for help with her income taxes and with her property tax credit application. Last year, due to staffing issues, Janet's tax credit application was not submitted, despite assurances from the outreach center that it would be taken care of and it would be submitted on her behalf. By then, the October 1st deadline to apply for the homeowner's property tax credit on her bill had passed. In December, she received a bill for over $2,400. She was shocked because she had always received a credit previously. It's the only way she could afford her home. She panicked. I took the application to her house to complete, gathered all of the documentation, which is a lot of things, particularly for older people to gather, scanned it, submitted it to ESTAT with a desperate plea to grant her an exception for the deadline. Luckily, they granted the exception and gave her the credit, but without reliable internet access or a copy machine or scanner, she would have had a really hard time completing this herself. So if Janet and others in her situation didn't have to apply annually, this could have been avoided. Allowing a 3-year period between the renewal of their credit would enable far more homeowners to pay their taxes and keep their homes. Thank you for the opportunity to testify.
Thank you very much. Are there any questions? Delegate Long?
Thank you, Madam Chair. You mentioned very briefly about the number of people occupying the property has not changed. How do you define that as far as you have a child moves in with you for a year or 6 months? How do you define the difference? Because I'll tell you what happened to me, and this is why I'm asking this question. A lady called me up and had received the property tax or the tax credit. Unfortunately, her son had to move in with her, and when he did, they started including his income. And it was just sad because, the lady could have lied and said, look, nothing's changed, but she did the right thing, and she struggled to pay her taxes. So I'd just like to know, how do you define a time limit if someone moves in a house, or what I'm saying?
Yes, I appreciate the question. So nothing in this bill prohibits the
family from submitting the full application if they want every year. This is just a new opportunity for certain individuals to not submit the full application. So to answer your question, on the short form, it will ask, please certify that you've resided in the property for at least 6 months in the previous year, and please check to certify that you continue to have only your income, and the last question will be, please check to certify that your household size has not changed. So in your situation, they would be invited to submit the full form again. They would not be eligible for this sort of shorter application. Again, if someone's income goes down, it might benefit them to fill out the long form application and not this short form every year. We're not taking away anyone's rights to do that. We're just trying to give them another opportunity to submit a shorter form if they qualify.
Right. Well, my question wasn't answered. How do you determine whether, let's say, another person moves in your house? How do you determine whether you claim as income? Because that's one of the specific questions they asked. How much household income do you have coming in? Am I correct?
That is what the law says, is that all the members of the household who live there for 6 months plus a day need to have their income considered for purposes of this tax credit. That's in the law. And this bill doesn't address that.
Okay, all right, thank you.
Delegate Long, council's going to address that.
Yeah, just to clarify that, so dependents, if you're a dependent and claimed as a dependent for federal tax purposes, then your income doesn't count. And also if you're paying rent, your income doesn't count. But anyone else who lives in the household, their income counts towards the homeowner's tax credit calculation.
Madam Chair, if I might, just want to make sure I heard correctly. Did you say if they're paying rent, they don't have to include their income?
Madam Chair, may I just, to clarify on that, the rent paid would count as income, but the income of the tenant doesn't count towards household income.
Right.
So,
that's right.
Yeah.
Okay, any other questions? Okay, seeing none, thank you very much. And that concludes the testimony on House Bill 897. And for the last bill of the day, Delegate Feldmark, House Bill 645. And I will call up Sharon Manecki, Samuel Anash, Ronza Othman, and then you have a couple of folks virtually that
Thank
will
you.
call.
Thank you, Madam Chair, Madam Vice Chair, committee members. Good afternoon once again. For the record, Delegate Jessica Feldmark here to present House Bill 645. House Bill 645 is to create a study on electronic ballot return systems. And
Madam
so this
Good afternoon. Ma'am, that is virtual. Just wait a minute and we'll call on you, okay?
So this bill deals with accessibility, particularly for voters with disabilities, and would also make it easier for voters overseas to return their ballots. As you know, we have worked hard to make voting as accessible as possible to individuals with disabilities so that they can vote independently and privately. And we have provisions for individuals to receive their ballots electronically, and they can fill out their ballots electronically. We do not have a way for ballots to be returned electronically. And that limits some individuals' ability to vote independently and privately if they need assistance for someone to print out the ballot and help them return it. So, so this bill sets out to establish a study to look at this issue of establishing a system for electronic returns. Now, I will say we have an amendment in the works, which hopefully we'll have to the committee soon. We are proposing to remove the request for proposals portion of this bill. So it would just be the study, not the request for proposals. And we are clarifying and strengthening the details for the study to really clarify the focus on security as a key component of the study, that we need to be looking for, focusing on security of electronic return systems. Also, focusing on the impact on the local boards of elections and specifying other details in greater clarity for the strength of the study itself and the detail of the study itself. So I think this is an important step forward. I know you will be hearing quite a bit from folks who have concerns about electronic ballot returns. And I think we need to look at election security and election access as two goals which we need to meet both of. We cannot compromise one for the other. So we cannot simply say, well, we're not going to pursue this. I think we need to pursue it. We need to study it. We need to look at all the possibilities, because we can and should be ensuring independent, private, secure voting to all of our voters. So I ask for your favorable report. I'm happy to answer any questions, and we'll turn it over to the rest of my panel.
Thank you. I would ask Sharon Manecki, a wonderful District 13 resident.
Yes. Wonderful representative, too.
Thank you.
Thank you, Madam Chair, Vice Chair, and members of the committee. I'm Sharon Manecki with the National Federation of the Blind of Maryland, here to testify in favor of this bill study, HB 645. This part of the election problem was passed in 2000. So in 2000, they said, the body here, maybe some of you were here, I don't know, maybe most of you weren't, but the fact is that they said there would be no electronic return. Well, the world is different now. There was no social media in 2000. You can buy everything on your phone and do your email and all this sort of thing today. So there are many things that couldn't be done in 2000 and can be done today. So there may be security situations that don't exist, that were prominent in 2000. So the time is right to at least study the matter, study it. So the people, we want to vote independently and we want to vote privately. And 12 states figured it out how to do it. They aren't any smarter than Maryland's are, we think. So, why not look at it again? Thank you, Madam Chair.
Thank you very much.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. My name is Ronza Othman, and I am the president of the National Federation of the Blind of Maryland. NFB of Maryland is the state's oldest and largest organization of and for blind, low vision, and deaf-blind individuals. I'm also a voter in Maryland. My ballot is neither secret nor private nor independent. If I vote by mail, something available to all of you, all Marylanders. I cannot do so as a blind person without help. I can mark my web-based ballot independently, but after that, anybody who has access to my choices who I might need to assist me. The electronic ballot requires me to print. Why, as a blind person, would I own a printer? So someone needs to help me and can see my choices. I'll need to sign and certify my ballot, and I'll need somebody to show me exactly where to sign properly, or I will be spoiling my ballot. So I will then be giving someone else access to my choices. I'll have to mail or get somebody to help me get it to a drop box, which gives them third access to my ballot. People have asked me about who I've chosen to vote for when they've assisted me, and they've also even tried to encourage me to change my ballot. I don't know if they changed it when they were helping me sign or print. No one has ever expressed concern about my security of my ballot because I have to use a paper ballot. This bill is simply a study, just a study. We recognize the security issues, and you're going to hear all about them. But 32 plus states have figured this out for military and overseas voters and 12 for voters with disabilities. Maryland can follow their proven record that security can be achieved alongside accessibility. As the delegate said, we do support the amendment. We think it strengthens the study. Happy to answer any questions and urge a favorable report on this bill. Thank you very much.
Thank you, ma'am.
Good afternoon, Chair Atterbury and Vice Chair Wilkins and members of the Ways and Means Committee. My name is Samuela Ansa, and I'm the voting rights advocate at Disability Rights Maryland, where we work to advance the rights of all Marylanders with disabilities, and I'm here testifying in support of House Bill 645. This bill will allow us to explore the ways technology can benefit the specific needs of voters with disabilities and those serving abroad by studying the idea of electronic ballot returns. Currently, Maryland offers voters with disabilities web-delivered ballots that have to be printed and mailed. And for those serving abroad, they are still limited to mail-in ballots, which are vulnerable to international postage. Electronic ballot returns for these two specific types of voters will aid in the feasibility of voting, increasing their participation. Whenever electronic ballot return is mentioned, people are immediately concerned about the security risk, especially given the narrative of the 2020 election. However, 31 states currently offer some form of electronic ballot return for specific voters, like voters with disabilities and those serving abroad. In my written testimony, I highlighted Denver and West Virginia, who use electronic ballot returns for those in uniform serving abroad in different countries around the world using blockchain technology, which I'm not familiar with. Each pilot program was less than 200 voters, and they saw a 98% and 82% return rate of those ballots, and no risk to the integrity of those ballots or their elections. While electronic ballot return isn't ready for widespread use for all voters, it can greatly benefit voters with disabilities and those who still find it difficult to vote with a mail-in or web-delivered ballot and those serving abroad. This bill will bring disability organizations and military communities to the table to study electronic ballot returns. However, we highly recommend that cybersecurity professionals also be invited to the table to address security concerns. For those reasons, we urge a favorable report on House Bill 645. Thank you.
Thank you. Are there any questions for this panel? Delegate Buckle.
Thank you, Madam Chair. And I really, Ms. Manecki and others from the Federation of the Blind and others deserve our best work at this to try to find a way to protect their right to vote and their right to do everything that all of us can do in society. So I heard a lot, the bill is it just disabled voters? Because we're talking a lot about overseas voters as well. So I'm very inclined to try to support something that works to help disabled voters, but I get a little hesitant. I don't really love the idea of being able to just email back and forth your vote in general. So is this limited to those individuals who are disabled, who have some certification that, hey, I need this technology in order to exercise my franchise?
So the bill as drafted calls for the study to look at both. I think it is certainly something that there could be recommendations that come out different for those different populations, right? So it is including those overseas voters in the study. It doesn't necessarily mean they would be included with the same recommendations as voters with disabilities.
And then my second question, I think you said you're offering an amendment that would remove the RFP process. I was just a little concerned of the timing of that. We're going to do a study and sort of presume that the study is going to lead to an immediate RFP, and that's going to be hard for the State Board of Elections to do. And it also sort of presumes we know what the study result will be. So you've kind of recognized that and said, hey, maybe we need to push the study back to a reasonable time. Or not the
Correct.
study, the RFP.
Correct. We're removing the RFP completely from the bill, so just focusing on a good, strong study to explore all the options.
Thank you.
Delegate Griffith?
Thank you, Madam Chair, and thanks for this bill. And I just want to follow up on some of Delegate Buckles' thoughts. Obviously, we want to make sure we're supporting election security for our disabilities community, and I'm all for that. But for bill sponsor, so on the military side, and not just military, it looks like anyone overseas, any overseas voter, you know, this is studying whether or not they would be able to vote. And obviously, the concern there would be we got to make sure any device on a military installation or somewhere in the middle of Russia would be completely secured to try to, you know, cast their vote. And so with that, I'm looking at letters in opposition by both. There's one letter signed by both Common Cause, the ACLU, amongst others, and a separate letter by Lear Women voters in opposition due to some of those security concerns. Can you please speak to that for us?
Sure. So I think, you know, with the amended bill, we will be focusing more specifically on security concerns in the study. And I think we would look to those recommendations. I do certainly understand that security concerns may be different in overseas context than with domestic voters with disabilities. And I would expect the study to evaluate that.
All right, thank you.
Any further questions? Delegate Long.
Thank you, Madam Chair. Just thinking about the study, I know they're talking about security and applying security. I know back in 2016, there was a lot of controversy about Chinese hacking into our elections. My concerns, and I'd like to ask you to expand on this, if we do this study, the study that you're doing might be good today, but because of technology, the way it changes, it might not be good tomorrow. Because, I mean, we have people hacking into, what was that? It was, I think it was the Marshals, United States Marshal Service. I heard there was a hack into that. And, I mean, there are some people that are really smart cookies out here not hacking in and stealing information. And that would be my main concern. Could you please address that? So, like, I just want to repeat and make sure I'm correct. If you do the study and it comes back and says, yeah, we can do it with this technology, that technology is only going to be good for a short amount of time. How will we address that?
Security is a very changeable thing, and nobody can, you know, you have to look for the balance, and nobody can answer what will happen tomorrow. I mean, you don't stay home because you're going to get every day, because you might get hit with lightning.
So if I can just add to that, this is a study, right? And so it's going to survey the 32 states that have something in place, including places like Louisiana and West Virginia, which have much less strong infrastructures than we do when it comes to voting. The Maryland State Board of Elections will not be able to implement this by itself once the study comes through. This body is going to have to change the law first and have some implementing legislation before anything would ever actually go live or before they would procure a system. And so there's going to be the opportunity to incorporate into implementing legislation what security requirements would need to be, provided implementing legislation happens, what security requirements, what assessments, but in addition, we'll be able to have through the study an assessment of what those other 32 states have done to ensure security. And there has never been a breach. There has never on electronic ballot return And some states have been doing it for quite a long time. Some states have only been doing it for 2 or 3 years. Many of the states have only been doing it for 2 or 3 years after the attention has really focused on election security. And so I think I'll just reiterate, this is a study. It's to get the information that we need to figure out what we should do or shouldn't do in the state of Maryland to ensure both security and civil rights. So we'll be able to get you that information, but not until after the study.
Any further questions from the committee? Delegate Ebersol?
Thank you, Madam Chair. So I was intrigued by a passing reference to blockchain, which is incredibly safe. Cryptocurrency is exchanged on blockchain, and people don't lose money unless they're poor investors in cryptocurrency, but they don't lose it because it drifts away. And I'm hoping that somewhere in your charge, you think maybe that will be picked up as something that would begin looked at. It's something that has been secure for many years in a row, actually, and I didn't know if you thought that you might have the expertise indicated in your bill for that or not.
No, I'm not a technology person at all, but in my written testimony in the footnotes, it links to the 2 studies that use the blockchain technology, the specific organization that organized the pilot studies for Denver and West Virginia. And they use the blockchain technology because it is really secure, from my understanding.
So I don't know if the sponsor would be willing to maybe slip that word into the bill somewhere, that they would just look at that as one of the possibilities, because it's going to be I feel like it'll be our future for online.
Okay. So I guess, Delegate, thank you for the suggestion. I personally don't feel I am either the technology expert or security expert to decide which specific examples to call out. Yeah. I think we're asking them to look at all of the security options and what those best practices are from this exchange. It sounds likely that blockchain would be part of that, right? But I wouldn't want to itemize specific security measures that I don't have a basis for knowing which ones to highlight and which ones not to.
Thank you. And I think my larger point is there are secure ways of transferring information on the internet that have existed for many years in a row here, and blockchain is one of those examples. Thank you.
Yes. So we hope they'll study that. And
I'm sure they will.
Yes.
Are there any other questions? We have some virtual witnesses in favor. I just have one question. I just want to reiterate, this is a study.
This is a study. Well, this would give this committee more information to continue this fascinating dialogue.
Thank you. I appreciate that. Okay, then this panel is done. Thank you. I'm going to call the virtual folks that are in favor. Phil Eanes or Enes? Dan Alpert.
Good afternoon. My name is Dan Alpert, and I currently live in Budapest, Hungary, and vote in Maryland. Thank you to Chair Atterbury and Vice Chair Wilkins for the opportunity to share my support for House Bill 645, which will require the Department of Legislative Services to complete a study on the creation of an electronic ballot return system. For the past several years, I've been very involved in the Maryland political sphere. Just last session, I was working for Delegate Foley of District 15, but in October of this past year, I relocated to Budapest to work with the Jewish community and support refugee services for those fleeing Ukraine. Now, a member of my local and state Democrats Abroad chapter, I have seen a different side of voter accessibility and voter engagement. Voting in last year's midterm election, I was simply able to place my ballot in a drop box and go about my day. When it comes to voting from abroad, it's a bit more difficult. For voters who live abroad, they are dependent on mail-in voting and also on a postal service, which may or may not exist depending on where in the world they are. You'll hear from individuals today who will share the cost of voting from abroad, along with the inherent difficulty of doing so. You'll also likely hear from others about states who have electronic returns as a secure method of voting. I want to conclude by restating what has been mentioned before, that this is simply a study that will be created to identify if electronic ballot return is feasible and secure for our state. It does not actually create the system itself. Given the bipartisan support of this piece of legislation, it's evident that individuals want to explore if this is possible, and I join them in that curiosity. This bill moves Maryland in the right direction because it provides a pathway to level the field for voters who experience various barriers, both in-state and living abroad. As a result, I urge a favorable report for House Bill 645, and thank you again for your time.
Thank you. Are there any questions for Mr. Alpert? Okay, seeing none, thank you. Melanie Gardner. Whenever you're ready, Ms. Gardner.
Yes, okay. Thank you, and good afternoon, Committee Chair Atterbury and esteemed committee members. My name is Melanie Gardner, and I'm a Montgomery County voter. I live in Ottawa, Canada. I moved here to join my husband in 2018. I'm a lifelong voter, and I take pride in voting in every election, from the U.S. Senate to the Board of Education. And having my voice heard and my vote counted. As a Maryland voter and a U.S. citizen living abroad, passing House Bill 645 is very important to me. While it may not seem like a long distance voting from Canada, it has not always been easy for me to do. In the 2020 election cycle, it was particularly stressful. In frustration, I reached out to friends and family about Postal Service times that they were experiencing as I prepared to mail back my ballot the day after I received it. In the end, what normally takes 7 to 10 days for postage, Postal Service between Ottawa and Maryland ended up being an over 5-week-long process instead of 7 to 10 days. I do not look back fondly at the many times I had to call the Board of Elections about my ballot status every day. 4 days prior to the election, I filled out the federal write-in absentee ballot, as is my federally protected right to do. I paid to send and sent it by UPS as an overnight delivery. So after much uncertainty, both ballots arrived the day before the election, and my vote was counted just once. I experienced the same in 2022. Deeply appreciative to Delegate Feldmark for introducing 645.
Thank you very much. Are there any questions for Ms. Gardner? Okay, seeing none, thank you. Jared Roche.
Committee Chair Atterbury, Vice Chair Wilkins, and committee members. My name is Jared Roush. I'm here in support of HB 645, and I extend my gratitude to Delegate Feldmark for introducing this important legislation. As you may remember from just 2 weeks ago, I serve as the Executive Director of Democrats Abroad, meaning I'm intimately familiar with how states facilitate the voting process for their uniformed and overseas civilian voters. One reason that overseas ballots are rejected is that they arrive after the ballot return deadline. Mail disruptions during the 2020 election cycle demonstrated how easily voters can be disenfranchised if mail service is not functioning properly. Even with optimal mail service or utilizing U.S. Embassy mail pouches, for many countries, it can take weeks or even months for mail to reach the U.S., especially with the COVID-19 pandemic and the resulting logistical disruptions. In addition to the slow pace and the risk of ballot loss en route, postal mail can be prohibitively expensive. If a voter opts to use a courier service to ensure their ballot arrives by the deadline, it can cost the voter between $40 to $100. Voting in every election could cost an overseas voter hundreds of dollars a year. The requisite study outlined in HB 645 is an important first step for Maryland to join the 2/3 of U.S. states, the District of Columbia, and the U.S. Virgin Islands, which already permit secure electronic ballot transmission, thus eliminating known barriers for voters with disabilities and overseas voters to exercise their right to vote. We urge a favorable report for HB 645, and I thank you for your time.
Thank you. Are there any questions for Mr. Rouch? Seeing none, Candace Kuristan.
Thank you, Committeewoman, and hello, distinguished committee members. My name is Candace Karistan, and I'm calling in my official capacity as State Party Chair of Democrats Abroad to ask for your support of HB 645. At the center of Democrats Abroad's mission is ensuring that U.S. citizens overseas, regardless of party affiliation, can and do exercise their constitutional right to vote. Overseas voters, including active duty military families, veterans, and civilians like myself, are guaranteed the right to vote under current U.S. law. Each state, however, determines the specifics of how and by when overseas voters can return their ballots. As you know, Maryland currently allows its overseas voters to return them by postal mail only. In contrast, the majority of U.S. states have now for several election cycles allowed for voted ballots from abroad to be returned through secure electronic means, such as fax, online upload, or an email attachment. This significantly reduces barriers to participation, as voters can easily return their voted ballots quickly and securely without the delays or costs associated with postal mail return. In fact, in each state where electronic transmission is possible, there is a robust and secure system in place. At the core of each system is a paper trail, meaning that a voter abroad must often download the ballot as a PDF, fill it out, scan it, and transmit it back to their local election official. There, a human being confirms receipt and tabulates the ballot. In some states where voters can return their ballot electronically to be counted on election day, they're also required to sit in a physical voted ballot, although without a set constraining deadline. In contrast to what Bill's opponents may say, electronic ballot return is not to be conflated with internet voting. Under no circumstance are voters abroad simply checking a box in a Google form to vote. Statistics often cited in opposition are borrowed from outdated domestic voter-focused studies in foreign countries. If anything, this relays the urgency of undertaking the study HB 645 foresees, so that this body has good data to use before making a final decision on electronic ballot return. There are many possibilities to facilitate this in the state of Maryland, and I appreciate your favorable report so that the committee can explore them. Thank you.
Thank you. Are there any questions? Okay, seeing none, thank you very much. And the last of the favorable, and this is favorable with an amendment, Elizabeth Landry, please.
Chair Atterbury, Vice Chair Wilkins, and committee. My name is Elizabeth Landry. Thank you for the opportunity to speak today. I am here in support of HB 645. I want to thank Delegate Feldmark for sponsoring this bill, as well as the bill's 31 House co-sponsors. I'm a Maryland voter living in Sweden, and I vote in Frederick. I was born, raised, and received my nursing degree in Salisbury. At the end of 2018, my partner and I moved to Sweden for their work. Maryland voters like me abroad are dependent on mailing in our ballots. In 2020, postal systems around the world were upended due to the COVID-19 pandemic, with so much uncertainty around the length of time that it would take for my ballot to get to Maryland. I ended up using a courier service to make sure that it got there by the deadline. This cost over $50 and was a modern day poll tax. We live frugally on a single income and must budget such a high expense. Having the ability to electronically return my ballot would save me money and stress of worrying whether or not my ballot will make it back to Maryland. I'm grateful for the study outlined in HB 645, and my position is favorable with an amendment requesting the inclusion of a public forum available online so that Maryland voters living overseas can give input on how such an electronic ballot return system would improve their ability to vote from their host countries. Thank you again for the opportunity to contribute my support and for your time.
Thank you. Are there any questions? Okay, seeing none, we have the unfavorable. Susanna Goodman, are you here? Yep, come on up, please. And then the rest are virtual. Oh, come up and tell me your name. I thought I just had one. I'm sorry, what'd you say? Okay, I don't have it, but come on up.
Okay, it's on? Okay. Good afternoon, Chair Atterbury, Vice Chair Wilkins, and the committee, and Delegate Feldmark. My name is Susanna Goodman. I'm here today representing Common Cause, the Brennan Center for Justice, the ACLU of Maryland, the National Organization Protect Democracy, and others. We are all voting rights organizations committed to ensuring that all voters can cast ballots without undue burden. However, I should say we had serious concerns about House Bill 645. We're grateful that Delegate Feldmark has heard our concerns and has offered to study this issue before mandating that the Department of Elections issue an RFP. During the 2020 elections, many states were looking to do internet voting because of the pandemic. It seemed to be a safe way to keep voters safe. And this concerned the intelligence community so much that 4 government agencies, the FBI, DHS, the Elections Assistance Commission, and NIST, issued this risk assessment, warning in no uncertain terms that sending ballots, returning ballots over the internet was high risk and that ballots could be intercepted and deleted at scale. That was just in 2020. And so there are many different august bodies that have looked at electronic ballot return and have pointed out the many unsolved security issues. So I really look forward to working with Delegate Feldmark and coming up with a list of those studies and those scientists. It's a really important issue, and I thank Delegate Feldmark for doing this.
Thank you, ma'am. Go ahead. We had you down as virtual. Go ahead.
Thank you so much, Madam Chair, Vice Chair. Thank you so much, Madam Chair, Vice Chair, members of the committee. I'm a PG County resident representing Public Citizen. As a voting rights advocate for 9 years, I work daily to ensure accessible voting for all. And there are a few really great accessible options worth exploring that don't involve returning ballots over the internet. But I just want to make sure that you're aware of one of the most recent disaster stories. Last year, the state that includes Sydney, Australia, had to rerun an election because of their limited for disabled and distant voters online voting system. More than 30,000 people trying to vote called the helpline for iVote, 30,000 people, and we're sorry for the inconvenience. An unknown number of people lost their right to vote in that election. The state had to sue winning candidates in 3 contests to force them to refundraise, rerun their campaigns. 19 more elections were in question, but they didn't rerun them because it was quite embarrassing already. We're strongly supportive of finding accessible non-internet return options. There are a few accessibility programs out there, and a couple of them I'll mention. San Francisco County has a broad-based ballot delivery system. They can bring anyone accessible voting equipment to their home. They can bring you a mail-in ballot if you end up in the hospital on election day. They can bring you a translator or a ballot in your language. Portland, Oregon, Multnomah County also has a similar program with bipartisan poll workers who come to your home, so you don't have to worry about who's helping you with that ballot that you print out. And there's a promising idea for voters overseas using identity verification that the IRS uses, and then having a poll worker on video help you verify that your ballot marks on paper were actually correct. Otherwise, you're basically trusting the system to mark what you intended with no way to ever verify that unless you give up your secret ballot. Thank you. Let's not repeat Australia's mistake.
Thank you. Are there any questions from the committee? I have a question for Ms. Greenhall. Did I pronounce that right?
She hasn't testified yet.
Oh, no.
But I can answer.
What is your name?
My name is Susanna Goodman.
Not you.
Akini Freechild.
Okay, I just crossed it.
It's the...
Yeah, okay, I got it. So Ms. Freechild, so you gave a couple of examples of how someone could come and help an individual who had some disabilities vote. And you suggested you could send someone that what was the term? Did you say bipartisan? Come to someone's home. So I don't know if you heard the testimony earlier from Ms. Ronza Othman, who went into detail actually about how she was concerned about how so many hands touch her ballot, and that how in the past actually someone tried to persuade her to vote for a different candidate. So do you envision any scenarios where if someone came to your home and they were bipartisan to help someone vote, say it's a highly contested election, like, you know, we had with our previous president of the United States, I could imagine somebody going to somebody's home and really trying to persuade them to vote for a different candidate. So are you suggesting that that would not happen because someone who's bipartisan came to help?
It's a team of a Republican and a Democrat that come to polling on the porch.
Oh, so you're saying it's two people come?
Yeah, it's
Okay.
nothing is perfect, right? I do think it's absolutely worth studying, but there are options for people who want to be able to vote at home accessibly without trusting a family member. Whereas you mentioned blockchain or any other way to secure a vote will not give you a secret ballot at the end of the day. Many of us trust poll workers in the polling place as well.
Well, I could also envision a scenario where there's a candidate for any office that is so polarizing that, and I'll just take my party, say there's a candidate that is so polarizing in my party, and even the members of my party felt that this person was just so awful that we were just going to support the other candidate. I mean, I can imagine, so you could have two people come from two different parties to help us vote, but then they really try to persuade someone not to vote for someone because that person could just be so polarizing. Maybe just because they're from two different parties doesn't mean they always disagree. My good friend over here, Delegate Griffith, and I have a bill together. We agree on quite a few things. So you don't see that as problematic.
Poll workers are not supposed to electioneer, and if they do, they should be fired. But I hear your point. There is no perfect system. It's just because it's a machine doesn't mean it protects the secrecy of your ballot or your privacy any better than a pair of humans who are sworn to be nonpartisan.
Okay. Any other questions? Okay, thank you. We will move to the folks that are virtual. And first, we will call Rebecca Wilson. Whenever you're ready, Ms. Wilson.
Chair Atterbury, Vice Chair Wilkins, and esteemed committee members. I'm Rebecca Wilson, co-director of Save Our Votes, Secure, Accessible, Verifiable Elections for Maryland, a nonpartisan grassroots organization that advocated for 12 years to move Maryland from unverifiable paperless electronic voting machines to the voter marked paper ballots we now use. And I've served as a chief election judge in Prince George's County since 2004. In recent years, we've stepped back from activism because in the current environment, it's a delicate balance to advocate for appropriate oversight of election technologies without undermining public confidence in our elections. But internet voting may raise legitimate concerns about election results. When Washington, D.C. planned to let voters upload their voted ballots to their server, they wisely invited security researchers to test the system beforehand. Within 48 hours, a University of Michigan team was able to hack in, access building security cameras, steal login credentials, reveal every secret ballot and change them to make a cartoon character win, and play the Michigan fight song each time a ballot was submitted. But election officials did not even notice the intrusion for 2 business days. Internet voting would erode the hard-won transparency and confidence that voter verifiable paper ballots have provided. In the current environment of domestic distrust of our elections, as well as the threat of foreign influence in them, we should be moving towards greater verifiability to restore the public's trust, which also helps protect the safety of our election officials and their families. So let's explore other ways to make our elections more accessible without transmitting voted ballots over the internet. The technology is just not there yet, and we look forward to supporting this study. Thank you so much for your time.
Thank you. Are there any questions for Ms. Wilson? Okay, seeing none, thank you. C.J. Coles.
Yes, hi. Thank you, Madam Chair and members of the committee. My name is C.J. Coles. I'm a former election official myself, and today I'm speaking on behalf of Verified Voting, a national nonpartisan nonprofit organization with a mission to strengthen democracy for all voters by promoting the responsible use of technology in elections. My organization was founded by computer scientists. We are hearing now that this is just a study bill. And fortunately for all of you, internet voting studies have already been conducted, even at the highest levels of government. As mentioned by my colleague at a different organization, Susanna Goodman, the Department of Homeland Security, the FBI, the National Institute for Science and Technology, or NIST, and the Election Assistance Commission, all agencies that are charged with protecting our election infrastructure. They've all come back and said the same thing. Voting electronically via the internet cannot be done safely and securely. This includes email, fax, website portal, or mobile app. So here we have the federal agencies charged with protecting our elections, the experts, and they're essentially saying, don't do this. And if this bill were to move forward, Maryland's elections could be at serious risk. It is nice to hear the sponsors say an amendment is forthcoming to remove the RFP requirement, and we would welcome that. However, today we have heard that the world has changed since the advent of the internet, but the actual truth is the internet has not fundamentally changed since the beginning. It is a communication tool, not a tool for security or privacy. No information shared on the internet, using blockchain or otherwise, is private. It cannot be, and that includes a vote. We know the challenges you face to assure every voter's ability to vote, and we strongly support interventions, some that were mentioned by my colleague at Public Citizen, Akine, but they must be instituted securely and verifiably. So at a time when election security and public confidence are under attack, electronic return of voted ballots opens the door to vulnerable and untrustworthy elections. And therefore, I request HB 645 be reported unfavorably. And I'd answer any questions you have.
Thank you. Are there any questions for Mr. Coles? Okay, seeing none, thank you. And the last witness of the day, Susan Greenhalgh.
Thank you, Madam Chair, Vice Chair, and members of the committee for the opportunity to testify in HB 645. I'm the Senior Advisor for Election Security at Free Speech for People, a national nonpartisan not-for-profit legal advocacy organization that is deeply committed to protecting and expanding voter access. But we oppose online voting for the security concerns and appreciate the proposed amendment from Delegate Feldman. Over the last 2 decades, there have been numerous studies conducted by federal agencies, think tanks, and academic researchers that have all reached the same conclusion, as my colleague at Verified Voting has discussed. This pertains to any electronic return of voted ballots or internet voting. This is a distinction without a difference. Voters casting ballots online cannot be reliably authenticated, and the ballots cast online cannot be effectively audited, and all of this makes online ballot return highly vulnerable to undetectable manipulation and hacking, which can be conducted at scale. Several studies on this, as we mentioned, there are numerous studies. I mentioned several in my written testimony and urge the delegates to look at it. Specifically, there's a study that was conducted by the U.S. Postal Service on blockchain online voting. There was also a study conducted of a commercial blockchain online voting system, which is referenced there as well. While it's true that more than 30 states currently allow electronic ballot return for some voters, it's important to note that most of these states decided to allow electronic return before the studies that we have all cited have been conducted. Quite plainly, the ballots cast online in those states are not secure or private as we speak. While there may be vendors that claim that their systems are secure and private, these claims are not backed by any independent security reviews, only the vendor's own self-serving promises. In fact, when independent academic researchers have examined systems such as Democracy Live or Votes, the system currently used in West Virginia, they found that ballots can easily be hacked and easily and undetectably hacked, and that the ballots are not actually private. We agree that Maryland should explore more accessible voting options for overseas and disabled voters, but we urge the committee to not to report HB 645 favorably unless amended as proposed. Thank you very much.
Thank you very much. Are there any questions? Okay, seeing none, thank you very much. And that concludes the testimony on House Bill 645. That concludes the bill hearings for the Ways and Means Committee today. Subcommittee chairs and back room individuals, we will convene at 4:20. It's 4:05. 4:20 in the back, please. Thank you to my sorors who hung in there with us all day, and we look forward to seeing you this evening.